That's normally so. uh, everybody's in the
Okay, Bullitt County, if you'll turn your camera off, we'll get to you in just a minute. Casey County, if you'll turn your camera off, we'll get to you in just a second, okay? Megan, is Mr. Wright supposed to appear on Zoom?
No, he's gonna be in person.
Okay, well, we'll pass over his case. What was the next case we promised to go to? Was it Casey County?
Yes.
Casey County, you can turn your camera back on now.
I have Brady Franklin.
Okay. Commonwealth of Kentucky versus Brandy Franklin. 21 CR 00119. Mr. Johnny Bell.
Yes, Your Honor. We had filed a shock motion for Miss Franklin.
Okay.
Your Honor, Miss Franklin, I know, has had some issues, as the court knows, with the drug addiction. Your Honor, I know that some things have been done in the beginning that wasn't good for the process. However, Your Honor, when a person is an addict, as the court well knows, a lot of times they're not truthful and they're not responsible. However, after this time in jail, Miss Franklin has advised me that she is not only willing, but wants to get some type of treatment, and would ask the court to consider any kind of release and allow her to get some treatment, and hopefully.
What does the Commonwealth have to say? You want to take some testimony?
I just want to confirm with Mr. Garner, she's got 157 days in. She had an opportunity to go to rehab and didn't. She has a parole date, July of 22. And Officer Garner told me he's already working on a parole plan for her. So I think that's the best route.
Yeah, she had an opportunity to do, did you hear what the Commonwealth just said?
I did, Judge.
Okay, what do you have to say in response to that? Don't you agree that she'd be better off on parole than she would be on probation?
Well, Your Honor, I could see pros and cons of both. Of course, if I was in jail, I'd want out on probation, and you know.
Well, if you were in her situation, you would have taken the rehabilitation opportunities too, I believe. And she
Well, yeah, I understand, Judge, but she has had a sickness for a long time. If the court wants to wait on the parole situation, could I ask the court to hold this in abeyance till after the parole date, and then we can
I
come
will
back?
do that. I will hold this in abeyance and see what the parole board does. Okay.
Thank you, Judge.
Okay. Bernice Stearns, do you have Bernice Stearns there?
Yes, she's coming. Right here she is.
Commonwealth versus Bernice Stearns. 19 CR 00106. Are you Bernice Stearns?
Yes, sir.
Your year of birth 1982.
Yes, sir.
The last four digits of your social security number.
0513.
Okay, we have a motion for shock probation. Counselor, what do you have?
Your Honor, Ms. Stearns was revoked by this court. She had had a pretrial diversion and it was voided by this court. At the time, we had asked the court to consider a drug court referral for Ms. Stearns. She would still very much like that opportunity. She understands that she made a mistake with probation and parole. As the
How
court
does the
made,
Commonwealth feel about drug court?
Well, she's another one that,
I'll let you go have to get up here and
okay. Give me just a second.
will you move away from the podium?
She's another person that has a parole date in October. Now, she was the lady that attempted to alter a drug stream by bringing in a condom full of urine when she was revoked. So if she feels like that she can behave in an honest manner and not be deceitful, I might be willing to put her in drug court.
You want to put her on for a second?
Yes, Your Honor.
Okay, Bernice, you raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, now tell me what's changed in your life that would make me believe that you could successfully withstand the rigors of drug court and turn your life around.
Your Honor, I admit I lied and I altered the test. I apologize to the court and I apologize to probation and parole for that. I was having, hard times. My mom passed away and now I've been given the chance to maybe better help myself and my family, and I would like to do that, sir.
Well, I will sign an order as far as a referral to drug court, and they can do an evaluation and vote on you. We'll see what you have. But now I want to tell you, this drug court is an avenue that some people use to straighten their lives up. But if you violate the drug court, you don't need to be asking me for any more breaks. You understand what I'm saying?
I understand, Your Honor.
Somebody will be up to see you. In Casey County, thank you for your cooperation. I don't believe you have anybody else for us, do you?
No.
Thank
Okay,
you.
y'all have a nice day up there. Thank you.
All right, thank you.
Out of custody, Jace Akery. Cumberland versus Jace Akery.
Morning, Your Honor.
Good morning.
Um,
22 CR 0032, Mr. Akery, or what's your year of birth?
9/5/91.
What year?
9/5/91.
1991 is your year of birth, and the last four digits of your social security number.
0836.
Okay, what do you have, counselor?
Judge, me and Mr. Stockton met at the settlement conference, and we have an agreement in principle. He has some cases in Wayne County. I think has a court date on June the 13th. And
What
we're
do you
going to
say,
try to work all
Mr.
those
Stockton?
out together.
Yeah, we've got our negotiation day on June the 10th at 1, so I don't see any need for him being here because that'll be before the Wayne County date. So Mr. Turner just needs to call me before the next motion day.
Well, here's the thing about it is, I don't know what they're gonna do in Wayne County. We're here today on him, and I don't want to that could be 3, 4, 5 months. He can do a plea here and they can work around it in Wayne County, is the way I look at it. So, I mean, he can do a plea today on this thing, or we'll set it for trial. What's your choice? You want to talk to him for a second?
Well, I need to talk to Mr. Stockton too.
Well,
Can we at least, like I said, if we can wait.
here's the thing about it, is our court operates different than some courts. We move our cases through. That way I don't have people sitting in jail waiting for trials. One of the things that bother me most is someone sitting in a jail waiting for a trial. And the way we do that is that we take seriously these negotiation days. And you either have a deal or you don't have a deal, okay? And we can't allow everybody to come up here on rule day and try to talk to Mr. Stockton while all these other lawyers are waiting here.
Right, and we did discuss it, Judge.
Well, yeah, but you didn't reach any resolution to it. So if you can't reach any resolution, the next step is to set a trial date.
If we can have that June 13th date in Wayne County, I will call him before the next motion day and we'll either have it resolved or we'll set it for trial.
Is that all right with you, Mr. Stockton?
Yeah.
Okay, that'll be fine.
When is that next rule day, Judge?
June the 23rd.
At 9 o'clock?
So I will tell you what, let's say if you're over there, what day are you going to be in Wayne County?
June 13th, Judge.
Okay, what day of the week is that on?
I think Monday.
Okay, Mr. Stockton, he'll contact you on the 14th, and you can arrange a negotiation day for him. And his next rule day will be on the 23rd, okay? 9 a.m. Thank you very much. Donna Allen. Senate. Donna Allen. Commonwealth of Kentucky versus Donna Allen, 21 CR 0040. Are you Donna Allen?
Yes, I am.
What's your year of birth?
February 29th,
Your year of birth.
56,
Okay. What are the last four digits of your social security number?
9377.
Okay, we're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation?
Yes,
report
I
on
have.
Probation and parole. Is it substantially correct?
Yes,
Is there any reason this lady should not be sentenced, counselor?
No, Your Honor.
On a plea of guilty to trafficking, controlled substance, second degree, second offense, 2 counts, the defendant shall receive a sentence of 6 years on each charge to run concurrently for 6 years, serving 180 days on in-home incarceration, the balance probated for 5 years, probation to be supervised. What's the court cost?
$180.
The court cost is $180. Do you need some time to pay that?
yes.
Okay, I'll let you pay it $30 a month.
Okay,
And the first payment, 30 days from the day you need to meet the probation and parole
Okay.
officer.
I sure
Okay?
will.
Mr. Wright, are you ready to proceed in your case now?
As far as I know, I am, Judge, I haven't checked on Ms. Costello, but I believe we're ready. Good morning, Judge.
Good morning. Commonwealth, this is Adair Circuit Court meeting in special session in Burkesville. Commonwealth, Kentucky versus James Boyd. Where's Mr. Boyd?
He's here, Your Honor. He's
You want to
coming
hit
up
Mr. Boyd? You want to come up? Now, I have read your motion in this case. Mr. Boyd, what's your year of birth?
12/28/65.
1965
Yeah,
is
yeah.
your year of birth. And what's the last four digits of your social security number?
9345.
Okay, will you come around and stand on this side of your attorney? Okay. Now, I've read your motion on double jeopardy.
Yes, Your Honor.
He hasn't been placed in jeopardy at all yet, has he? The jury hadn't been sworn. Has he been tried on one of these cases?
No, Your Honor. He's currently facing.
So
the charges.
what your challenge is to whether or not the elements of 1423 and 1421 are different enough that he should be tried on two separate offenses. Is that what your motion is about?
Yes, Your Honor.
Okay, you want to move over to your left away? Yeah, move over to your left. Okay, what do you have to say in response to that?
Well, Judge, the first comment I would make is I think that this is essentially a motion for a directed verdict on one or the other. And I sort of agree with the indication of the court. Implication you just made in that question is that this would be better presented at the close of the Commonwealth's proof. I would say that in this case, there were 18 marijuana plants found outside of Mr. Boyd's home. There was 171 plants found inside the home. And there was around 14 pounds of processed marijuana found inside the home. So our position is that the cultivating will be based on the plants that he was growing and harvesting in and around his home. And the trafficking will be based on the pounds of processed marijuana that was found. So I think those are two separate offenses, much like if you were caught with methamphetamine in the car and then a meth lab at another location, that would be two separate offenses. So that's our position, Judge. It's not.
You want to move over? What do you have to say in response to
Your
that?
Honor, in response to that, I would, in 1423, the cultivation statute covers, it says unlawfully plants, cultivates, or harvest marijuana. I would argue that you can't have processed marijuana unless you harvested it.
Yes, you can. It happens every day. It comes in from Mexico.
Well, that is true, Your Honor, and I
That's
think
true,
if
is you got two separate offenses here. You got the cultivation offense, you got the possession offense, and, you know, I just, do you have a case on this?
no, Your Honor, I could not find a
Well, I guess you're
single.
gonna get the opportunity to create one then, because I'm gonna deny your motion.
I understand, Your Honor.
Okay, and when are we set for trial? Is that next week?
Wednesday, Your Honor,
Wednesday,
next Wednesday,
okay.
June 1st.
Okay, well, now, this is your last opportunity if you want to talk to Commonwealth about any kind of plea or anything, because we're gonna be up there ready to go.
Your Honor, I have relayed the Commonwealth's offer to Mr. Boyd.
Okay, we'll see
Again,
you on Wednesday then, okay?
thank you, Your Honor.
Can Ms. Costello and I approach, Judge?
Yes. Wait just a second, I got my approach button, I don't see it here. Here it is. Hold on.
two things. One, there's also the expert witness motion. I think that's been
Oh,
resolved.
yes, that's why I didn't bring it up. Miss Andrews from your office sent me everything I need. I think the only thing was she wasn't sure quite who was going to be testifying from the lab, and should it be the other person she was going to supplement with her resume.
But Rebecca is testifying only as the chain of custody.
Okay.
Allison will be testifying.
Okay, make sure they got the jury coming up there.
Yeah. Now, I want to make everybody aware. My son qualified Monday for the state tennis tournament up in Lexington. It starts Tuesday. If anybody that's good, I'm not going to object. But if he's playing in Lexington on Wednesday, Lacey's prepared to try the case. She'll be there. We're ready to go. There's no issue.
Who's gonna try the case?
Lacey, my assistant. Lacey Andrews. She's working with you like getting ready. So it'll be one or both of us there. I
Okay.
plan to be there, but.
Well, you know, you got a right to sign whomever you'd like to from your staff.
Good luck. So
I won't be in the office Tuesday, so,
Okay.
and I won't, there's a holiday, so like I said, if he wants to do something.
he does.
Okay, we'll see you on Wednesday.
All right, thanks, Jessica. I assume that. I'll be there.
Annetta Burton, the clerk on Tuesday, informed me that they were.
Okay. Okay, thank you.
Thank you.
Yep. Joseph Arms. Joseph Arms. Commonwealth Kentucky versus Joseph Arms, 20 CR 0068. We're here for a pretrial.
Your Honor, when we were in court last month, the court indicated it was overruling our motion to suppress.
Yes.
But if the court's entered an order, I haven't seen it. Well, we're going to have time to digest it and decide what we want to do. If you can pass the pretrial another month.
Yeah, I'd ask if we have one more pre-trial in June, if there's no resolution, we'll set trial.
Correct.
What day was it? June the 10th?
It is, but Mr. Cross can't be there, so I told him he needs to make arrangements.
I know where his office is.
Well, you'll be back here on the 23rd of June. And then it is also a condition of your bond that you respond to a date provided by your attorney to be there for the negotiation date. Whatever date you choose, Mr. Cross, your client needs to be there.
Thank you, Your Honor.
Michaela Beatty. Commonwealth versus Michaela Beatty, 21 CR 00128. We also have Tyler Beatty. Is that a companion case?
Yes.
Do you represent both these individuals, Mr. Richardson?
I do. There's been a waiver.
Okay, have they signed it in open court?
Yes,
They
sir.
signed it last time?
Earlier than last time.
Okay, so what do we have on this case?
I'm going to defer to the Commonwealth here.
Okay, we all move to your left then.
Yeah, Mr. Richardson requested that he be able to speak to two witnesses. Those two witnesses are minors, but they're not in the cabinet's custody. We've had difficulty finding those two witnesses, and just this week, we found them located in Byrdstown, Tennessee. And we're trying to make arrangements for our office and Mr. Richardson's office to interview those children. And I would ask that we set this on June the 10th. I don't know that I can get them to come up here voluntarily, but I can get them up here for trial if I need to. And so, I can do a subpoena, but what we can, if the court will grant us an order, if we can try to subpoena them for the June 10th date.
I will grant that order.
And if they don't come, and then we'll go from there.
How old are they?
They're young. I think one may be a teenager. Yeah.
14 or 15.
So I'd have to subpoena the parents.
Okay, look,
But if I can't get them for the 10th, I'll try to.
present the order and include an order that they should be here on the 10th. There's no reason for them to be here on the 23rd.
No, there is not.
Okay. And then if they are provided the opportunity the next court date for these individuals will be on the 23rd of June. And we can, and if we'll address the issue of the witnesses then and have a plea or set a trial date, okay?
Okay.
Thank you.
On the 10th, we need to be here what time?
9, and you know, I would think since your minor,
I've got on the road motion negotiation at 9, they take 1 o'clock.
1 o'clock on the 10th, okay. And since those minor children might be here, well, you probably should try to take them first.
I'll have some extra help.
If we could get them here before 1, you and I could interview them.
No, what I'm saying is I won't be here before.
Oh, okay, I'm sorry.
Commonwealth versus Jonathan Bowen.
Your Honor, I have another case if you would take it now.
Okay.
If
Wait just a second, Mr. Bowen. What do you have?
Set up. It's David Capps, Your Honor. It's 21.
Commonwealth versus David Capps. They had Rich on there.
Yes, and I'm saying.
Commonwealth versus David Capps, 21 CR 0092. Are you David Capps?
Yes, Your Honor.
You born in 1966?
Yes, sir.
Last 4 digits. What is that?
We've got a.
Okay, we'll just keep it there. Just keep it there for a second.
1429.
We're here for a pretrial conference. I understand that you have a plea. Is it a misdemeanor plea or a felony plea, misdemeanor plea?
Yes, sir.
Mr. Capps, a motion has been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes, Your Honor.
You just lower your mask just for a second.
Yes,
You
Your
take it back up. Okay. Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes, Your Honor.
Are you the same person named in indictment number 21 CR 0092?
Yes, Your Honor.
Have you discussed this matter with your attorney? Are you fully informed about your case and are you satisfied with his advice?
Yes, Your Honor.
Before I can accept a plea, I need to inform you of certain rights you have under the Kentucky and United States Constitution. I'll go over those rights and then I'll ask you if you understand them. You have the right not to testify against yourself. No one can make you say anything. The right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charge. You understand that by entering this guilty plea, you give up those rights. Now, I may accept the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. Now, y'all move to your left over here. Ms. Anderson, what is the recommendation of the Commonwealth?
Upon a plea of guilty to assault 4th degree, the defendant shall receive a sentence of 12 months, probated for 2 years. Probation is to be supervised. Unsupervised, I'm sorry. Thank you. The defendant agrees to have no contact with the victim. The defendant shall pay court costs at the discretion of the court, and the victim is in agreement with this.
Okay, what is the court cost?
$220.
You need some time to pay that?
No.
Okay, well, you can pay the court costs. I will accept the plea. And since this is a misdemeanor, I can go ahead and enter the judgment today. Is that your signature on the document there?
Yes, Your Honor.
Okay, Mr. Bailiff, will you deliver that to the clerk? And I will sign the judgment today. The Commonwealth prepared a normal judgment on the form, Mr. Richardson, and you need to meet with the probation and parole officer. Here's the judgment they have here, and I'll sign it.
Even though it's unsupervised, he needs to meet with them.
Yes. We'll just get some information, Okay,
Thank you, Your Honor.
yes. Okay. Trial be need taken off the docket. Let me see here. What was it? Yes.
discussion about this yesterday. I just wondered, I don't know if I made a mistake or not, but on that Brown board that's set for June the 8th, that wants to represent himself,
Yes.
do you think he ought to have a council appointed some kind
I
of?
don't know what the proper procedure is. I don't think he'll allow anybody sitting here.
You're probably right, but he just doesn't know anything
Well,
about
you
the
look it up and if
procedure.
you think that, I had told him the same standard and we had the hearing, so if you want to take a look it up to protect your Commonwealth's
I think
case.
I'm going to.
Okay. Jonathan Boland. Come over to Jonathan Boland. 22 CR 0039. Are you Jonathan Boland?
Yes, sir.
What's your year of birth?
1985.
And the last four digits of your social security number, Mr. Boland.
7772.
You're here today for the purpose of arraignment. You have the right to remain silent. This is just a presentation of the charges against you. Are you representing the Office of Public Advocacy?
I've represented him before, Your
I
Honor.
continue the appointment. You have a right to remain silent, okay? The grand jury of Cumberland County has returned an indictment charging you with license plate not eligible for possession of controlled substance in the first degree, Class D felony. Possession of drug paraphernalia, driving on a suspended driver's license, failure to notify address change to Department of Transportation, and inadequate muffler or silencer. You understand those charges?
Yes, sir.
You acknowledge, counsel, you acknowledge the identity of your client, receive the indictment, wait formal reading arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
We have the negotiation day at 1 p.m. on June the 10th. With the next rule day on June the 23rd. I'm assigning a reciprocal discovery order, Mr. Boland. And they just gave your attorney information to help her prepare for your defense. Both of these dates are part of your bond, and you need to be present on those dates. You understand? Thank you very much. Amanda Branham says active warrant. Mr. Stockton?
Yeah, that's for their NCIC. Looks like.
Okay. Benjamin Birchfield. Has he been served?
He hasn't served in long enough.
Who's on his bond? First name is what? Tina Wells signed his bond.
Surety bond.
So
We can just get a copy of that.
need to revoke his bond. Bond is revoked for failure to appear. Issue a warrant for him. Brandon Burris. Says active warrant out for Mr. Brandon Burris. You got that, Mr. Stockton?
Yeah, I do, yeah.
Okay. Christopher Cooksey.
Here.
He had what?
But he was paid in full.
I was going to dismiss this case. I don't know if he did in prison or not because he paid the restitution.
No, I think he's got another issue that has arisen downstairs unrelated to this. If you're ready to dismiss this case, I have no problem. Go ahead and dismiss it.
Leave it credit.
If he objects to the case being dismissed,
He does not, Your Honor.
we'll have a competency hearing for him.
Yes.
Christian Cooper. Commonwealth versus Christian Cooper. 22 CR 0027 and 22 CR 0028.
Your Honor, we have a resolution. We're just waiting on paperwork. If you'll give us about 5-10 minutes.
Okay, well, I'll come back, Mr. Cooper. They say that you've resolved this or reached an agreement. So we'll, as soon as I get the paperwork, we'll call you back up. So you just have a seat back there, okay? William Davidson. Mr. Poindexter, that was your case, and this is just a motion to destroy evidence. So you have no objection. Lonnie Duval. Lonnie Duval. Commonwealth versus Lonnie Duval, 22 CR 0030. We're here on a pretrial conference. Mr. Duval, what's your year of birth?
1971,
Okay, and the last four digits, of your social security number, sir.
5942.
Okay, we're here on a pretrial conference. Y'all have a resolution of this?
We do not, Your Honor. We met at the settlement conference. I would ask the court to consider one more before setting a
What
trial
is the
date.
charge, Mr. Stockton?
It's a possession and I offered, the person drug court.
Mr. Duval had some questions about drug court that I couldn't quite answer for him.
Okay, what kind of questions you have about it?
We just couldn't come to an agreement, you know.
Well, now, she said you had questions about drug court.
Yeah, but I don't remember what it was.
Okay. We just set it for trial then. You have all your witnesses available. Do you need a lab or anything?
Need a date so we can check the beats because there'll be a lab. Long.
We have Commonwealth versus Stout over in Monroe County, Mr. Stockton.
Yes.
You think that?
I may have prematurely set the trial. We might want to set this one. I said I may have prematurely set that when there was some confusion. I thought there was some facts that weren't correct. So we might want to set this one in the back. If you want.
Okay, well, let's just set this one on the 29th for trial
Of which month, Your Honor? I'm sorry.
of June.
June. Okay.
Wait a second. Is that the new jury? Okay, we'll have to set it before that, Mr. Stockton.
Or we could set it a little after.
No, I can't set it after.
Oh, that's right. Well, I'm looking to see if we have the lab.
I think that was one of the questions.
We can't get it, let's know. What about the 27th, 28th?
Let's do it on the 28th.
Is there any way we could do the 27th, Your Honor? Only ask because I have a dare rule day on the 28th, and the person that normally does that court with me is out that week. He said the 28th, and I asked for the 27th because I have a deer circuit that day, and the person that normally covers is.
Okay, on the 27th.
Thank you, Your Honor.
We don't have a, we have a rule day on the 23rd,
Yes.
so that's too close to the trial date. So we'll just go to trial, okay? If you have any motions to suppress or anything like that, you can file them on that day. Okay? Edsel Elliott. Combo versus Edsel Elliott. 21 CR 0046 and 21 CR 0047. You Edsel Elliott, your birth is 1955. Your year of birth 1955.
Yes, sir.
Last four digits, social security number 9094. What do we have?
Your Honor, could Mr. Stockton and I approach briefly?
Yes.
Your Honor, I believe we have a resolution. The only concern is Mr. Elliott sleeps with oxygen at night. And I haven't got clearance to the jail for it to allow him to have that, and his sentence would require a 180-day alternative sentence. And I just didn't know if the court would allow him to report in on the 3rd so that I can get clearance with the jail for him to have that in and get all his medication together.
Is the jailer here today?
He's got diabetes medications, and I know they'll give him his medications. He's just got to get them there.
It's two undercover drug guys. One was 4 grams of meth, and the other was 2 grams of meth, so I don't think it'd be undue with harm.
No, and he understands that he has to serve the sentence. He just has to breathe.
I'm not going, they can take care of that. They're bound to have people on oxygen.
That's what I would think. He doesn't have that with him in the court, so I don't know if he could go home and get it and take it up there, or how the court wanted to handle it.
But we need to have somebody to call the jail. Nobody here representing the jailer's office today? We call the jailer.
You want me to go ahead and tell them to do the paperwork?
Y'all don't have the paperwork done yet?
No, we'll have to do it.
We were concerned about the
We'll
oxygen.
come back to the case then.
Okay.
Call Thomas J. Brown.
Calling Thomas Brown. Mobile.
We have circuit court going on, and Edsel Elliott is wanting to enter a plea, but he's on oxygen. Will you call up there to the Dade County Jail to see if he needs to bring his own oxygen, or they provide it for him? Well, yeah, and see if he needs to bring his own oxygen. He's not that, he's not like deathly ill or anything. He's just on oxygen. He sleeps. And do that. Well, he's wanting to enter a plea today. Just find that out, and we'll take a plea today. Okay, you call me back, okay? That was a jailer. He's going to contact the county jail.
Can we go back to that Benjamin Birchfield that you issued more on? When the jail bought him out, they bought him out for May 31st. I called him with his letters. And she was filming.
Did you hear that, Mr. Stockton?
No.
On Benjamin Birchfield, the jail bonded him to the 31st.
They put May 31st on his bond. I called him up with his mother and told her the right date.
Okay, we'll wait till 6 days, that's next quarter, that's all right.
Well, the next court dates, the court date will still be wrong. The- He shows up today, we'll deal with it. If not, we'll set him for the 23rd, June the 23rd, but we won't. Do what?
If he shows up on the 31st in the office.
Yeah, but I would tell her that he needs to come on over here today. I'm not gonna make a decision at the end of the docket. He needs to come on today, okay? Barry Gibson. Barry Gibson, Commonwealth versus Barry Gibson, 22 CR 0037. Are you Barry Gibson?
Yes, sir.
Born in 1969?
Yes, sir.
Last four digits, your social security number.
9632.
You have an attorney today?
No, I don't.
Get back, move over behind the podium. Just move over behind the podium now. Why don't you have an attorney?
I'm in contact with one. I'm just trying to get my finances in order to.
Okay, well, I'm gonna ask public advocacy to sit in for the purpose of arraignment. Who are you in contact with?
Dehart. Mr. Dehart from Russell Springs or Jamestown.
Yeah. This is Mr. Barry Gibson. He's here for the purpose of arraignment. I'd like you to stand in for that purpose only, and then you'll be relieved, okay? The grand jury of Cumberland County has returned an indictment charging you with equipment of vehicle not a nuisance, wanton endangerment in the first degree, 2 counts. Possession of controlled substance in the first degree, fleeing or evading the police on foot, tampering with physical evidence, possession of drug paraphernalia, failure to maintain insurance, no registration plates. Counselor, do you acknowledge the identity of Mr. Gibson to receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Mr. Gibson, we're gonna let you have a copy of that indictment. You and your attorney be here on June the 10th. And the next court date is June the 23rd.
I'm gonna give you one of my cards so you have the dates, okay? But just give this to Mr. Dehart, okay?
Both of those are requirements of your bond.
Okay.
Okay, thank you.
Thank you, sir.
Cromwell versus Joseph Grider. Cromwell versus Joseph Grider, 22 CR 0015. Are you Joseph Grider?
Yes, sir.
Pull your mask up over your nose if you would. You born in 1982?
Yes, sir.
Last four digits, social security number 9076.
Yes, sir.
Jailer, excuse me a second. Yes, sir. But they'll let him bring his own, right? Okay, okay, thank you. Jail said that they will let him bring his own tank.
Okay.
And if he runs out, then they can provide it, but they just got one tank up there now.
Okay.
Okay. Mr. Grider, you're here for a pretrial conference. Have y'all reached a resolution in this case?
We have, Your Honor.
Is it a felony plea or pretrial diversion? What is it?
Diversion, Your Honor.
Mr. Grider, a motion has been filed that says that you wish to enter a plea today. Are you currently under the influence of drugs or alcohol?
No, sir.
Are you the same person named in indictment number 22 CR 0015?
Yes, sir.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes, sir.
Review, take your mask up over your nose. Do you believe that you've been fully informed about your case?
Yes.
Now, you have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go down through all of them. At the end, I'll ask you to understand that. You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses to call testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to fire the Commonwealth with on a reasonable doubt you're guilty of charge against you. You understand that by entering this plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may reject it. If I do reject the Commonwealth's recommendation, you have a right to withdraw your plea. Have you previously been diverted in the last 5 years?
No, sir.
Have you had any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you fully complete the diversion program, the charges will be dismissed, pretrial diverted, and you can have your record expunged. But you also further understand if you do not complete the diversion program, you will be brought back before the court, and the court will schedule a sentencing after hearing a pre-sentence investigation report done by probation and parole. At that point, you'd be a convicted felon in jail again. Hello? Okay, he will. Okay. Okay, bye. They said because of the holiday weekend, make sure he brings enough medication to last through Tuesday too. Okay. Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Okay. Ms. Anderson, we all move to your left. I want you to listen very carefully, see if this is what you agree to.
Upon a plea of guilty to flagrant non-support, the defendant shall receive a sentence of 5 years, pretrial diverted for 5 years. Diversion is to be supervised. The defendant shall make a monthly payments at a rate of $269.18 per month on regular child support payment, plus $100 on arrearages, for a total of $369.18 per month to be paid to the Cumberland County Division of Child Support Enforcement, IVD number 4540609. First payment is to be paid on or before June 1st of 2022 and on the first day of each month thereafter. Defendant owes a total of $6,690.77 as of February the 1st of 2022. Defendant must pay the balance in full at the end of the diversion period. The defendant is to pay court costs at the discretion of the court, and the defendant shall obtain gainful employment or do a minimum of 30 hours community service until gainful employment is obtained.
What is the court cost in this case? Court cost is $185. I'll let you pay that at $30 a month, unless you can pay it today. Can you pay it today?
No, I need some extra time.
Okay. I'll give you 30 days from today. You make your first $30 payment, and $30 every month. You pay $185. Is this what you agreed to?
Yes, sir.
Is that your signature?
Yes, sir.
Well, accept the agreement, and sign the diversion order. And you understand that if you get revoked on this, it'll be a felony conviction. It can be used against you in further felony cases. You understand that?
Yes, sir.
Okay, you need to meet with a probation and parole officer. Dwight Harold. We got the pre-sentence investigation. You are Dwight Harold?
Yes, sir.
What year were you born, Mr. Harold?
71,
Okay, last 4 digits, social security number.
4088.
Okay, you are here for the purpose of sentencing. Are you standing in for Mr. Wittenberg?
Yes, Your Honor.
Okay, have you had a chance to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Okay, is there any reason, counselor, he should not be sentenced?
No, Your Honor.
On a plea of guilty to operating a motor vehicle, alcohol concentration 0.08 above, under the influence of substance, he should pay $200 fine and court costs. On a plea of guilty possession of controlled substance first degree, 2 counts, he will receive 2.5 year sentences to run consecutively, a total of 5 years, serve 60 days in home incarceration with a balance probated for 5 years. He shall be permitted to go to work, church, and doctor's appointments during that time. Defendant shall receive credit for time served. He shall obtain gainful employment. He should agree to have any and all of the drug paraphernalia and contraband destroyed. How much is the court cost and everything on this one together? $845. I'll let you pay that at $50 a month. Okay, the first payment coming 30 days from today. Now, have you made arrangements to be hooked up?
Yeah, I've had it on for a month already.
Okay, so you're already hooked up. You need to meet with the probation and parole officer.
I did that last month too.
Okay, well, you just check with him over there. Yeah. Mr. Bailiff, you understand on these DUIs also that you plead guilty to a DUI could be enhanced in the future. Another DUI would be have a greater penalty. You understand that?
Yes, sir.
Okay. James Hurst. James Hurst. Commonwealth versus James Hurst. 22 CR 0013 for pretrial conference and arraignment and 22 CR 0038. Are you James Hurst?
Yes, sir.
What's your year of birth?
1970,
The last four digits, social security number.
2119.
Okay, you've already been arraigned on one of these charges, but the other charge you haven't been arraigned on. You've got a right to remain silent. If anything you don't understand about this arraignment, step away from the podium and ask your attorney, okay? The grand jury of Cumberland County has charged you with trafficking and controlled substance first degree, tampering with physical evidence, possession of marijuana, possession of drug paraphernalia. You understand those charges?
Yes, sir.
Okay. Counselor, you acknowledge your receipt of indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motion.
Yes, Your Honor.
About what, this case?
Yeah, they said they're gonna warn you.
Yeah, serve him with a summons. You already out on bond, and when they indicted you on this, instead of getting a warrant for you, I just had them do a summons. Go ahead and serve it on him and just put the return on it.
And Your Honor, I did want to advise the court, Mr. Hurst's case is going to be a conflict case. I've already been working on that though. And so we're hopeful that by the June 10th date, we can have his conflict attorney in place.
June the 10th at 1 o'clock, you'll be here for negotiation.
Yes, sir.
And then June the 23rd, you'll be here for your next court appearance. Did you keep a copy of that where you served it? I know there was only, so I hand it over here and she make a copy for the file, okay?
So my bond stands good.
Yes.
Yeah, yeah. I mean, you showed up today.
I've showed up every time.
I
sir.
know you, that's the reason I didn't issue a warrant for you. I didn't want you to have to go through the process. All right, okay. Okay, Jody Jones. It says active warrant, Jody Jones. Mr. Stockton. Okay. James Krieg. This is active warrant. Okay. Michael Nedry. Michael Nedry. Commonwealth versus Michael Nethery, 22 CR 0020. We're here on a pretrial conference. You, Michael Nethery?
Yes, sir.
Born what year?
64,
Last four digits, social security number?
8105.
What do you got, Council?
Your Honor, we were unable to reach a resolution. We will need a trial date.
What is the charge, Mr. Stockton?
Trafficking methamphetamine, he had about 5 grams of meth according to the lab.
What was the offer?
No, I didn't write it down. I think I'll do that last time.
It was time to serve.
It was time to serve.
Yes.
Everybody in the public knowing out here about the deal with the trial schedule, but he's not at the same thing on Ronnie Duval, but we set Mr. Nether at the same date because I don't have a lab, on Mr. Duval. I don't know if I'll have it time for the trial. But if I do.
What date was it?
Was it 27th or 28th?
We sent Mr.
27.
Duval for the 27th.
Okay, got it. See you on the 27th.
Thank you, Robert.
Robert Purdue. Robert Purdue. For Raymond. Combo versus Robert Purdue. UCR 0046. Are you Robert Purdue?
Yes, sir.
Born in 1963. What year were you born?
Thursday,
What year of birth?
1963,
Last four digits of your social security number.
3514.
Okay, the grand jury, you have a right to remain silent. You're represented by Mr. Cross. The grand jury of Cumberland County has returned an indictment charging you with trafficking and controlled substance in the first degree, possession of drug paraphernalia, failure to maintain insurance, operating under the influence of alcohol or other substance, operating commercial vehicle while under the influence, possession of marijuana, possession of open alcoholic beverage, expired registration plates, and speeding. You understand those charges?
Yes, sir.
Okay. Mr. Cross, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty.
Yes, Your Honor.
Observing all pretrial motion. I've signed a reciprocal discovery order, Mr. Purdue, that requires the Commonwealth to provide you with evidence prepared for your case. You should be here. You and Mr. Cross will schedule a pretrial negotiation with the Commonwealth, and you'll next be here on June 23rd for your court appearance.
Your Honor, regarding Mr. Purdue and his bond conditions, I've had some discussion with Mr. Stockton. Mr. Purdue's going to have to find a new line of work. He's not going to be driving a truck anymore. And the pretrial, the curfew and the no driving are eliminating his ability to get out and find work. He has no record. He's a reputable fellow. This is the first bauble he's ever had. And
well, all he needs to do, if he needs to go to apply for a job or something somewhere, he just needs to call pretrial. I'll allow him to do that.
Okay. And then if he gets a job, what do we do?
Well, he's under conditions of bond. He can go to work, work, church, or the doctor's, what it says.
Can he drive, Your Honor? He has difficulty in going and.
Well, I don't know whether he can drive or not under his suspension. He's suspended now, isn't he?
No, he has no pretrial suspension now.
Well, I don't want him out operating generally, but if he gets work and we get the location down to the work, he can go back and forth to work.
Fine, Your Honor. Appreciate that.
Okay, Amanda Reynolds. Amanda Reynolds. 21 CR 0094. We're here for sentencing. Are you Amanda Reynolds? Have you had an opportunity to look at the pre-sentence investigation report done by probation pro?
Yes, Your Honor.
Is it substantially correct?
Yes, Your Honor.
Counselor, is there any reason why this lady should not be sentenced today?
No, Your Honor.
On plea of guilty to trafficking and controlled substance first degree, the defendant shall receive a sentence of 5 years, serve 120 days on in-home incarceration, about probation for 5 years. The defendant agrees to pay $1,000 in lieu of forfeiture, or will agree to forfeit the 2000 Nissan Frontier vehicle to the sheriff's department. The defendant shall pay court costs in the amount of what? $665, $265, and you shall obtain employment, contraband destroyed. Now, you're gonna need some time to, what are you gonna do? Is forfeit the vehicle or pay the $1,000?
I already got it.
You did what?
I've already got it back.
He's already paid. You got the
You paid the $1,000, okay. The court cost was 201, 265. You need some time for that?
I'll pay that today.
Okay. Okay, well, you need to meet with the probation pro officer over there, okay? Caitlin Riddle. Commonwealth of Kentucky versus Caitlin Riddle. 22 CR 0014. Are you Caitlin Riddle?
Yes, Your Honor.
What's your year of birth?
2001,
Last 4 digits, your social security number.
4568.
Okay, what do we have here?
Your Honor,
Commonwealth motion, Your Honor, she was assessed, she was to be placed in the drug court. She was assessed and not accepted due to her statements of lack of use, so I'm asking that she be placed on
Because of her what?
lack of use of any type of drugs. She claims she didn't have a problem, so I was asking that she be placed on supervision with probation pro.
and Your Honor, the last time we were here, because when she entered the plea, because she was not yet accepted, the court did have her report to probation and parole, and she has been reporting to them since she entered the
She
plea.
doing okay?
She's okay, Your Honor.
Okay, well, you say you don't have a problem with drugs. I hope you don't. You need to stay the heck away from anybody that's got any drugs.
Try to.
Yeah. And if anybody brings any drugs out on you, everything you need to say, get thee behind me, Satan. Move on, okay?
Mhm.
Is the Commonwealth satisfied with that?
Yes.
Okay. Go forth. Joshua Vibbert. Joshua Vibbert. Twenty-two CR 0021 Commonwealth versus Joshua Vibbert. We're here for a pretrial conference.
Your Honor, I was hired in this case Monday and have not even looked at the discovery. All I've done is made arrangements with Mr. Vibbert and entered an appearance. So if
What is the charge in this case?
fleeing and evading primarily.
Okay. You need to, Mr. Vibbert, you and your attorney need to set up a negotiation date with Mr. Cross at the Commonwealth, and you're next to be here on June the 23rd. Both appearance at the negotiation and 23rd are both conditions of your bond, okay?
Thank you, Your Honor. Your Honor,
James Wagers.
Your Honor, one additional thing, Mr. Vibbert is still on home incarceration. He's on very limited income and they've had to hire counsel. Can we get that lifted?
No, I don't know if he's complied with other conditions of his bond here. I've never been furnished any proof that he's had a mental health assessment done. Well, that's what I'm saying. He's not-
Well, y'all just need to work on it, and right now is not the time to do it, okay? James Wagers. James Wagers. Commonwealth versus James Wagers, 22 CR 0023. Are you James Wagers?
Yes, sir.
You born in 1989?
Yes.
Last four digits, social security number 7049.
Yep.
You here for a pretrial conference. What do y'all got?
We have a diversion offer, or diversion plea, Your Honor.
Okay. Mr. Wagers, I've been informed that you wish to enter a plea today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 22 CR 0023?
Yes.
Is your judgment impaired today?
No.
Have you discussed the charges with your attorney? You feel like you're fully informed about the case?
Yes, Your Honor.
Are you satisfied with her advice?
Yes, Your Honor.
You have certain rights under the Kentucky United States Constitution. Before I can set the plea, I need to know that you understand those rights. I'm going to go down through there, and when I get finished with them, I'm going to ask you if you understand it, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak trial, but jury right to be represented by counsel to your trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witness in your favor. Right to appeal this matter to higher court if you lose. Right to file the Commonwealth prove on a reasonable doubt that you're guilty of the charge against you. Understand that by entering a guilty plea today, you give up all those rights.
Yes,
I may consider the Commonwealth's recommendation that I may apply any range of sentence provided by law, and if I do not accept the recommendation and reject the plea agreement you sign, you can withdraw your plea. Okay? You understand, if you fully complete the diversion agreement, the charges will be dismissed pre-trial diverted. Have you previously been diverted in the last 5 years?
No.
You have any felony convictions in the last 10 years?
No.
Are you currently on probation?
No.
You step to the left here, Ms. Anderson.
Yes, Your Honor. Upon a plea of guilty to possession of controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, pretrial diverted for 3 years. Diversion is to be supervised. The defendant agrees to be assessed and follow any recommendations by the social service clinician. The defendant shall pay court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth of Kentucky. Defendant shall remain on active supervision until all court costs are paid in full and until further request of probation and parole.
Is that what you agreed to?
Yes, Your Honor.
You realize that if you complete this diversion program, the case will be dismissed pre-trial diverted. You have it expunged. However, if you don't successfully complete the diversion program and you get brought back in here and I revoke your pre-trial diversion, I have a pre-sentence investigation report done by probation parole, and you'll be sentenced to be a convicted felon. This can be used against you in the future, in another felony charge. You understand that, to enhance the sentence? You understand that?
Yes, Your Honor.
Is that your signature?
Yes.
Okay, well, I'll accept the agreement and sign the diversion order. What are the court costs in it?
$310.
What? $210. You need some time to pay that?
Yes, Your Honor.
Yeah, let's pay $30 a month, starting 30 days from today, okay? You can pay those on time.
We can trade right here.
Probation parole officer, okay?
30 per month, okay.
Joseph Willett,
Um, 30 days.
Joseph Willett, Commonwealth versus Joseph Willett, 22 CR 0040. Mr. Willett, were you born in 1984?
Yes, sir.
Last four digits, your social security number
1455.
1455. You have an attorney here with you today?
I do not.
Then why don't you have an attorney?
I don't have the money for one right now.
Yeah. Okay, well, I'll appoint a public advocate to represent you, and you can fill out the affidavit to see if you're.
Thanks, sir.
You have the right to remain silent. If you have any questions concerning what's going on, step away and ask Ms. Costello. The grand jury of Cumberland County has returned an indictment charging you a failure to use a seatbelt. Possession of controlled substance, first degree, possession of drug paraphernalia. And license plate, not legible. Counselor, you acknowledge the identity client received the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Can you be here on the 10th of June at 1 o'clock for negotiations? Yes, sir. And on the 23rd of June for your pretrial. Okay, both those are conditions you bond. Commonwealth versus Robert Young. Sign the reciprocal discovery order, sir, and they'll give you evidence to prepare your case. Commonwealth versus Robert Young. 22 CR 00025. Are you Robert Young?
Yes.
You have an attorney?
Yes, Your Honor.
Okay. Mr. Young, what's your date of birth?
78,
Okay. Last four digits, of social security.
3613,
Last four digits.
3613.
Okay, you're here for a pretrial conference. Y'all have any resolution?
Yes, Your Honor. We have a felony plea.
Okay. The motion been tendered says that you wish to enter plea today, Mr. Young. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is plea freely and fairly given?
Yes, sir.
State your full name.
Robert Lee Young.
Okay, are you the same person named in indictment number 22 CR 0025?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you had plenty of time to discuss this matter with your attorney, and are you fully informed about your case?
Yes, sir.
Are you satisfied with her advice?
Yes, sir.
You understand that you do not have to enter a guilty plea today. I have to go over your constitutional rights with you. At the end of that, you can tell me whether you understand them or not. You have a right not to testify against yourself. No one can make you say anything. You're at the speed trial, but jury right to be represented by counsel at the jury trial. Right to confront and cross-examine all witnesses, called testify against you, the right to produce evidence, the right to call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter higher court if you lose, the right to file a comment to a reasonable doubt that you guilty charge against you. You understand that by entering a guilty plea, that you give up those rights. And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by the law. Prior to accepting your recommendation, I will await pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation? Will you all go to the left here? Listen very carefully to what Ms. Anderson has to say.
Upon a plea of guilty to wanton endangerment first degree, the defendant shall receive a sentence of 5 years probated for 5 years. Probation is to be supervised. Upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above a 0.08, or while under the influence of alcohol or other substances, third offense, aggravating circumstances, the defendant shall pay a fine of $500 and serve 60 days in jail. The defendant shall receive credit for time served. Defendant shall pay a fine and court costs at the discretion of the court. Defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. Defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth of Kentucky. Defendant shall remain on active supervision until any and all fines and court costs are paid in full and until further requests of probation and parole.
Is that what you agree to?
Yes, sir.
Okay. Now you understand that you have a felony plea that it could enhance pleas in the future if you get another felony. And also a DUI is enhanceable too. If you get another DUI, it will be more serious because of this plea. You understand both those things?
Yes, sir.
Okay, well, I will accept, I will order a pre-sentence investigation report to be done by probation, parole, and set your sentencing for June the 23rd. Has he served his days yet?
Yes, Your Honor. I think he's up to almost 90, actually.
So he's got no additional time to serve. Okay, I will allow you to remain free on bond. You live at the foot of the cross between then and now. You understand what I'm saying?
Yes, sir.
Okay, and you need to go over there and meet with the probation parole officer to get the information there. We only have one other case that's left on the docket, and that's Commonwealth versus Kristen Cooper. You have the paperwork done on that? Y'all have the paperwork done on that?
On Mr. Elliott, he is reviewing it now, Your Honor. And I think Mr. Poindexter.
The review of her, his client.
Wants to review it here or go back there?
I'd rather you've already reviewed it, but just sit down there at the table there and go over it with her. Who is? Well, we're finished for him already. Yeah, so we don't need him. He's done, but we don't need him this. You know, he's good with us. Whatever he's in, is he on a deep domestic violence or what's he about that? Some type of. In district. Just tell him we don't have any, but he's finished here, you know. We go to Bullitt County next, is that right? Bullitt, we got one little case we're gonna finish, then we'll be right with you here. We got a plea. I'll go ahead and do it now. Commonwealth, Kentucky versus Christian Jones. 21 CR 0068 and 19 CR 0084. Bullitt County Jail, Christian Jones.
Yes, sir.
You can come up here, counselor. You'll be all right.
Okay. Your Honor, this is the defense motion for shock for Mr. Jones. He's being held on two separate cases. His probation was revoked by this court in March, actually, Your Honor. He left treatment. He was sent there. He did leave treatment and he admitted that to this court. There was another individual there that he had a strong history with, and he did not think he could be sober in that environment. And he left, and he did not immediately report back to his probation officer, which is why this court revoked him. Mr. Jones, though, has sat now for several months in the jail since he was picked up on that warrant, and things
Is
about
that
where.
what he's been held on? Has he been held
Yeah.
on something else?
No, it was this case, Your Honor. He had a criminal trespass in district court.
What's he doing in Bullitt County?
The jail transferred him to Bullitt County.
Why was that?
I think overcrowding at Adair County, Your Honor.
What do you have to say, Mr. Stockton?
Well, Mr. Jones on.
Come on up here so we can hear you.
On the earlier case, was on probation for theft. He had a 5-year sentence. And while he was on probation for theft, he committed another theft. And he got 5 years on that. So it's got a total of 10 years. He's got a parole eligibility June 23rd. And, you know, that's the one thing I get complaints from people on is the theft. around here. And, you know, it's one thing to have an addiction, but it's another thing to start taking people's property. And I just don't think he should be shot.
Yeah, I'm gonna take it under advisement and see what the parole board does.
That's a year from now, Your Honor. That's a whole nother, that's a whole nother year from now. It ain't,
Yeah, I think it's June of 23.
He's right, it's June of
2023. I had permission to cut the firewood, Your Honor. I had permission to cut the firewood from Linda Smith, where the theft come in at. And she changed, the property changed hands. It was, and the new owners got mad about it. It was one tree. Your Honor, this has shocked me. I've got a 2-year-old daughter.
Wait just a second.
Well, the first one was up for timber, but now the other one was.
What was the second one?
Or the second one was the timber. The first one was.
My property.
Wait just a second, sir. Wait just a second.
The first case, Your Honor, was a house that he had lived in with another person and then had moved out. And I think the owner of the property maybe had passed away and then it was sold. And he was back at the property getting his items and some other. It was
my stuff.
Wait just a second. If you say anything else, I'm just gonna see you next year, all right? You understand what I'm saying?
Sure.
Okay. Mr. Stockton, will you look into it just a little bit? You're gonna have to come up here because he can't hear you there.
Well, I would agree with the timber. There was an estate as the victim on the timber case. The other one, I'm just not familiar with. I have to look into. I know they were both theft charges. And he was probated. Yeah, the other one was Brian Wright. I believe.
Yes, that's why Mr. Stockton's not familiar with the facts.
Yeah, well, explain the one to me, sir, where you were inside somebody's house.
Yes, sir. It was my residence. Lisa Lira up at 125 Pleasant Hill Road died. And she left the property to her girlfriend Donna, which in turn Donna left it to me. And when I was in jail at the time that the property was foreclosed on by the bank, and when I got out of jail, I went the next day to get my personal belongings, my clothes, and my kids at school, old school work from when they was in grade school up there in Birchville. And Scott Daniels had a camera set up in the rafter and got me coming out of the house with a box of my little girl's schoolwork. And it was my stuff. I wasn't stealing anybody else's stuff. It was my personal stuff, but the bank had foreclosed on my house, so technically I was trespassing. It was second-degree burglary originally. It got amended down to third-degree burglary because I took the plea. But I promise you, I wasn't stealing anybody else's stuff. And the house was already broken into. The doors was kicked open, the windows was busted out. I'm not sure if you're familiar with 125 Pleasant Hill Road up there. The property went up for sale in 2019 or 2018, I think.
Yeah, tell me about the wood.
Okay, 2 Februarys ago, Linda Smith owned property next to us on 61 South, 140 Manson and Georgia Thomas Road is my address. And the property right next door, she was in the process of selling, and she said I could cut up any dead wood that was on the ground or any trees that were dying for firewood. To keep, if during COVID I couldn't get a job, couldn't get a ride nowhere, and I had to get firewood. And she allowed me to go over there and cut wood, but I cut down a walnut tree that had been broken off of top. The land is swampy area, and all the trees in that one area right there beside, it's right on the highway there, are all dying because it's a swamp, the ground's sinking. And anyway, the new owners, they own the boat storage place beside of Moon's garage there, going on 61 South. They were the ones who bought the property. Okay, they came and I walked the property line with them. They told me not to worry about it. The tree that I cut down, they seen it, I showed it to them. And but the son had gotten mad at me for doing it. I guess it was the son who bought the property, the daddy. I don't know the people very well. I just met them that one day. They talked Linda Smith and the person charging on me for cutting that tree down, for stealing that tree. On the first, but Officer Tweedy come to my house, took me down there to talk to Linda Smith and the new property, the soon to be property owners. And Officer Tweedy
even in the grand jury on the desk that they give me in my discovery, he said that Stockton asked him if Mr. Jones had permission to cut the wood down.
It's all day.
It's all big
Wait
misunderstanding.
a second.
I'd ask the court to go back and read the crime stories on both PSIs. And you'll either find that Mr. Jones is the unluckiest person in the world, or he's not being completely honest.
I am being totally honest.
I just asked that you read the crime stories.
Okay, well, I'll take it under advisement. Okay, I'll go back and look at the pre-sentence investigation reports and take it under advisement. We'll be in contact with you one way or the other, Mr. Jones. Thank you very much. Okay, Hardin County.
Yep.
Hardin County. See Hardin County on Hardin County Detention.
Good morning.
Good morning, Sydney Cross. Commonwealth versus Sydney Cross, 21 CR 007 and 21 CR 006. Are you Sydney Cross?
Yes, sir.
What year were you born?
1998,
Last four digits of your social security number.
1560.
Okay, we're on a pretrial diversion revocation. If you move to your left, sir.
Yes.
What do you have, Mr. Stockton?
In this case, Ms. Cross tested positive for meth and marijuana. She also had clean urine on her person. I don't know if it was hers or somebody else's. Mr. Cross is wanting her.
Wait, Jerry Joyner.
Yes, Your Honor.
Are you, what's your involvement in this case?
He's her probation officer.
Yes, Your Honor. I'm her probation officer.
You raise your right hand. You swear the testimony you're about to give us the truth, the whole truth, nothing but the truth.
Yes, Your Honor.
You may inquire, Mr. Stockton.
Mr. Joyner, what violations has Ms. Cross had since you've been supervising her?
The violations I had were use of controlled substance meth, use of controlled substance marijuana. She admitted to using both of those. Basically, I had a call, anonymous call, that she had relapsed and was very concerned, and the person was very concerned about her. I had a officer do a home visit and left a door tag. Miss Cross had called me, and I gave her a date to arrive on April 29th. She arrived at about 3:45 and initially stated she couldn't pee at the time. She first admitted to using marijuana, and then she couldn't go I was trying to get an actual lab test. So then she tried to go again and couldn't go. And then I was going to let her go home. This is Friday afternoon and come back 8 o'clock on the following Monday. And she was in the lobby and left her purse in the bathroom. And the officer that was trying to drug screen her observed syringes in plain sight. And at that time, we contacted Jeremy Garner from Cumberland County Probation Office, and he advised us to put a detainer on her. Ms. Cross denied using intravenously. Cross did state that she finally did admit to using methamphetamine with marijuana. She signed admission sanctions form for the use of marijuana and meth on April 27th. After receiving permission to detain Ms. Cross, once in the car to transport her to the detention center, she stated that she had clean pee on her person and that she couldn't actually use it because of the probation officer was observing her the whole time. And then.
Okay, that's enough.
I don't have any other questions.
You have
Okay.
any examination?
No, sir, I do not.
Okay, will you stipulate the violation?
Does Ms. Cross stipulate?
Well, I'm going to find that she's violated pretrial diversion order, pre-sentence investigation report done by probation and parole. Have her to come back here on June the 23rd for sentencing.
Judge, I would like to make a note that she is going to be assessed by the Hardin County Mental Health Board. It's a pilot program.
Well, they can take care of her after she finishes what we do. Okay, thank you very much. Thank you, Hardin County, for your participation. Officer, thank you.
Thank you.
Okay, y'all are excused. LaRue County. LaRue County. LaRue County. I guess we need to check, see if LaRue County is on the line. Warren County. Warren County. Wayne County, please turn your camera off. We'll be to you next, okay? Warren County. Thank you very much. Commonwealth Kentucky versus Randy Metter, 19 CR 0078. Are you Randy Metter?
Yes, sir. I have a couple of questions, Your Honor, before we get started.
Well, you have the right to remain silent. Your attorney is here. Do you need to, is it something you need to ask her?
Well, I've been trying to get in touch with her since the last time we met, last month, with no avail.
We've been playing phone tag, Your Honor. He's correct. He's
Okay.
called from the jail and I've called back and they haven't been able to get us on the line together.
What is the revocation? Let me, wait just a second, Mr. Metter. What is?
He's got on probation, he got 4 new felony convictions out of Barron County. He's a state inmate, so he needs to be revoked so he can get all these running together.
Do they say, Mr. Metter, that you have 4 felony convictions and that in order for your time that you might receive here to run together? But I'm going to go ahead and continue your case until June the 23rd so your attorney can talk to you about it. Okay, I don't feel comfortable. You're already a state prisoner, correct?
Yes,
Yes,
Your Honor.
sir. And I'm doing a 5-year sentence. When I'm
What
done with the 5 years, I have to go to rehab for a year.
Okay, well, what we'll do is I'll have your attorney to contact you and see what we can do as far as wrapping this up into what you're already doing, if that's okay with the Commonwealth, okay?
All right, thank you, sir.
Okay, Warren County, thank you for your cooperation. You're excused, okay?
Thank you, Your Honor.
Yeah. Did LaRue County ever come back on? If not, let's go to Wayne County. Wayne County. Wayne County. Wayne County, turn your camera back on, please. Thank you so much. Lisa Dobbs, are you Lisa Dobbs? 21 CR 00105. Miss Dobbs, what's your year of birth? You gotta turn the microphone on. Somebody gotta turn the microphone on. Lisa Dobbs. Little thing that looks like a microphone used to look like in 1940s there, so. Somebody know how to turn the microphone on? There should be at the bottom left of the screen, a little thing with a red cross across it there. Thank you very much. Are you Lisa Dobbs?
Yes, sir, I am.
Okay. This is 21 CR 00105. What year were you born, Miss Dobbs?
1965,
Last 4 digits, social security number.
5491.
We're here on a probation revocation. Mr. Stockton, what do you have to say?
I need, this is possession controlled substance, 1st degree, 3-year sentence. And Ms. Dobbs tested positive for meth back in November of last year. Then according to Officer Sexton, she never set up her followed through with her treatment program, and I've got her to testify by Zoom.
Okay, Officer Sexton, will you turn your camera on?
Yes, Your Honor.
Raise your right hand.
I'm starting my video. Yes, Your Honor.
For the testimony about to give us the truth, the whole truth, and nothing but the truth.
I do.
State your name and whom you're employed in what capacity.
I'm Suzanne Sexton. I'm employed by the Department of Corrections as an officer for probation and parole.
Ms. Sexton, how long have you been supervising or attempting to supervise Ms. Dobbs?
Ms. Dobbs came to my caseload November 9th of 2021.
Has she had any positive tests for any contraband or illegal substances?
She did have a positive for marijuana on November 12th of 2021.
Was she also positive for meth on that day?
She was positive for meth, yes, on that date, and the lab results confirmed it on November 18th.
Okay, did she deny use as the reason there was a lab result?
She did deny use. She advised she had used cold medicine, Sudafed, and it felt that was why she tested positive, but she denied use of meth and reiterated that she had taken Sudafed for cold.
Okay, did you set her up? What did you do after she had that positive test?
I did, as a sanction, I did set her up with a social service clinician and advise that she would be to follow any and all recommendations made by the social service clinician.
Did she actually see the social service clinician?
She did. She met with her. She was assessed by the social service clinician on November 22nd of 2021. And the social service clinician recommended that she be enrolled in outpatient counseling at Adonta for substance abuse and to follow all recommendations.
And what date did you say she met the social service clinician?
That was November 22nd of 2021.
Okay, and did she follow through with that and set up counseling or any kind of substance abuse counseling?
She was involved in counseling at Adonta, and whenever I met with her monthly, she would tell me that she was, had an appointment with Adonta, et cetera. On March the 2nd of 2022, I saw that the social service clinician had entered a note stating client does not appear to be attending her recommended treatment through Adonta. That's what clued me in because she follows as far as treatment and follows whatever recommendations. So I contacted Adonta on March 7th to follow up. And Ms. Dobbs was being seen there for mental health counseling, but she was not being seen for substance abuse counseling, which is what she was referred to by probation and parole.
So did she even have a treatment plan or anything set up at Adonta for substance abuse?
At that time, I was told by Casey with Adonta that she did not, that there was no treatment plan for that. She did acknowledge that she had an appointment with Kenita Matthews, and that was thought to be mental health at that time. And since then, I have gotten a statement from Adonta, and it showed her appointments, and they were with Kenita, but they were all for mental health. They were not for substance abuse, according to Christy Chadwick with Adonta.
Okay, I have no further questions.
Yes, Officer Sexton, you have been supervising Ms. Dobbs since November of 2021, correct?
Yes, correct.
And she had, the only positive test that she had with you was in November of 2021. Is that correct?
I have not tested her since then.
But she's been reporting to you, correct?
She has been, yes, ma'am.
Okay, and she has been going to Adonta, but for mental health counseling, is that correct?
She did advise me she was going there for mental health, yes.
Okay, and when you met with when you spoke to Adonta, they confirmed that she was going there for counseling, is that correct?
For mental health, yes.
So she was being counseled and you haven't tested her since November, is that correct?
I have not tested her since November, that is correct.
So you don't know if the mental health counseling that she's receiving is sufficient to address her issues, do you?
The mental health counseling had nothing to do with the referral from the social service clinician. It was strictly for substance abuse counseling.
But you don't know that she's continued to use, do you?
I do not. I have not tested her since November 21.
Nothing further, Your Honor.
No reiterate.
You want to call your client?
No, Your Honor. I think that.
Not a good sign. What do you have to say, Mr. Stockton?
Mental health issues along with substance abuse issues. I think if she would go and set up and get a treatment plan and be sanctioned, that would satisfy the Commonwealth in this case.
Ms. Dobbs, how long have you been in jail there?
22 days today, sir.
Okay, well, I'm going to sign you out today,
Thank you.
22 days. But I want you to cooperate with your probation and parole officer, and you go over there to Adana and you get a substance abuse program established, and you give her notice of it within 1 week from today. You got
Yes,
one
sir.
Officer Sexton, she's to report to you within 1 week of today to confirm that she's following the clinician's recommendation.
Yes, sir.
And the officer, if the officer reports to me that you have not done that, then I'm going to issue a warrant and you're going to spend some time back over there. Do you understand that, Ms. Sexton?
I do. Yes, sir.
Okay, thank you very much.
Thank you.
Thank you.
Yeah. Okay, we have Jason Craig.
Yes, sir.
Commonwealth versus Jason Craig, 21 CR 00106. Are you Jason Craig?
Yes, sir.
Okay, we're here on a pretrial conference. What is your year of birth?
1978,
Last 4 digits of your social security number.
7123.
Okay, what do we have here?
Your Honor, Mr. Craig was on the docket for last month and the court issued a bench warrant for him and he was picked up on this and maybe a probation issue as well. So Mr. Stockton and I were hoping we could set this for a settlement conference.
Okay,
I don't mind doing that. I just want Mr. Craig held because he was at a rehab and left.
okay, 6/10, June the 10th at 1 o'clock here for a negotiation, and 6/26. 23rd, isn't it?
Yes.
The 23rd of June for the next court appearance and the 10th for negotiation. And I think that concludes what we have in Wayne County. Thank you all very much for your cooperation. Your attorney will be in contact with you, Mr. Craig.
Thank you. Thank you, sir. I apologize for last month too.
Well, okay, I appreciate that. Adair County. While Adair County's turning on, do we have Ms. Cooper finished?
Yes, sir.
We'll bring her around. Adair County, you'll be next. I've got one live case here. Yeah, that's right. Adair County, if you just turn the camera off just for a second, I'll get right to you, okay? Commonwealth of Kentucky versus Kristen Cooper, 22 CR 0027. We previously identified your year of birth as being 1985. Is that correct?
Yes, sir.
And the last 4 digits, social security number 2196.
Yes, sir.
Okay, what do you have here, Mr. Poindexter?
It's a plea for pretrial diversion.
Okay, a motion has been tendered, ma'am, that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
You're the same person named in these 2 indictments. Let me see here. 22 CR 0027 and 22 CR 028. That's you, correct? Have you had plenty of time to discuss this matter with your attorney? Have you reviewed the evidence Commonwealth has against you? And are you satisfied with his advice?
Yes, sir.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to a higher court if you lose. You have a right to require the Commonwealth prove on a reasonable doubt that you're guilty of charge against you. Understand by entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I'm not applying range of sentence provided by law. I do not have to accept the recommendation. In the event that I do not accept this recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. Ma'am, have you been previously diverted in the last 5 years?
No, sir.
You had any felonies in the past 10 years?
No, sir.
You understand if you complete the diversion agreement, the charges will be dismissed.
Yes.
You understand if you do not complete the diversion process, be brought back before the court, a pre-sentence investigation report would be ordered and you'd be sentenced, you'd be a convicted felon then. That
I
can
do
be used to
understand.
enhance things in the future. Understand that?
Yes,
You
sir.
move to your left. Ms. Gordon Anderson. What is the Commonwealth's plea?
Upon a plea of guilty to possession of controlled substance, first degree, in case number 22 CR 27, the defendant shall receive a sentence of 2.5 years. Upon a plea of guilty to possession of controlled substance, first degree, in case number 22 CR 28, the defendant shall receive a sentence of 2.5 years. These two sentences are to run consecutively for a total of 5 years. Pretrial diverted for 5 years. Diversion is to be supervised. The defendant is to be assessed and follow any recommendations of the social service clinician. The defendant shall pay court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth of Kentucky. The defendant shall remain on active supervision until all court costs are paid in full and until further requests of probation and parole.
What's the court cost? Is that what you agreed to, ma'am?
Yes, sir.
Okay, now there wasn't a DUI involved in this, was it? How much? You what? I'll merge the court cost on the thing. How much is that? $295. That'll save you $200. When can you pay the $295? Need some time?
I'm sorry, I couldn't hear
Need
you.
some time to pay the.
Yes, please.
Okay, you can pay starting $30 a month, first payment due 30 days from today.
Okay.
Now, is this what the agreement, is that what you agreed to?
Yes.
The
yes,
agreement
sir.
was read. Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
Okay, now, is that your signature on the documents?
Yes, sir.
Mr. Stockton, why was drug court not considered? Okay. Y'all want to approach?
Do I come?
You can come to.
My understanding is Ms. Cooper's taking Suboxone through a clinic.
I put myself in a program the day I got out of jail.
Okay, all right. So that's, listen, the reason I ask that is not to try to be punitive to you, but it's not easy sometimes. And
Right.
I don't want to set people up to fail because if you fail, I'd have to send you to penitentiary. You
Right.
understand what I'm saying?
Yeah, I
Okay,
do.
that satisfies me. Okay, thank you. I will accept the agreement and enter a diversion order. You do need to meet with the probation and parole officer over there to get full information, okay?
Okay.
Thank you. Good luck to you. Okay, now we still have Mr. Elliott here. Edsel Elliott. Do you have a plea agreement?
Yes, Your Honor.
A felony plea, is that what it is?
Yes, Your Honor.
Okay. Mr. Elliott, this is 21 CR 0046 and 21 CR 0047, and you've previously been identified in the court. Are you currently under the influence of drugs or alcohol?
No, sir.
Are you the same person named in indictment 21 CR 0046 and 21 CR 0047?
I am.
Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with her advice?
Yes, sir.
You believe that you understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and United States Constitution. Before I can accept a plea from you, I need to know that you understand your rights.
Yes, sir, I understand.
You have the right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to a higher court if you lose. The right to acquire a Commonwealth prove beyond a reasonable doubt that you're guilty of charge against you. That you understand that by entering a plea today, you give up all of those rights.
Yes, sir.
Okay. Now I want you to listen very carefully to the Commonwealth's recommendation. Ms. Gordon Anderson, will you tell them what?
Yes, Your Honor. Upon a plea of guilty to indictment number 21 CR 46 for the charge of trafficking in a controlled substance first degree first offense and persistent felony offender second degree, defendant shall receive a sentence of 10 years. Upon a plea of guilty to indictment number 21 CR 47 for the charge of trafficking in a controlled substance first degree first offense, a class C felony, defendant shall receive a sentence of 10 years. The 10-year sentence in indictment number 21 CR 46 and the 10-year sentence in indictment number 21 CR 47 shall run concurrently for a total of 10 years. Serve 180 days in jail with the balance probated for 5 years supervised. The defendant shall enter and complete the Cumberland Specialty Program. The defendant shall receive credit for time served and shall obtain gainful employment or do a minimum 30 hours of community service per week until gainful employment is obtained.
Yeah, I'll wait for gainful employment if Mr. Elliot's not able to.
The defendant agrees to have any and all drug paraphernalia and contraband destroyed in a manner consistent with the laws of Commonwealth of Kentucky and the holding agency.
Is that what you agreed to, Mr. Elliott?
Yes, sir.
You realize that entering these pleas, they can be used against you in the future for future felony conviction to enhance your sentence and persistent felony offender law. Do you understand that?
Yes, sir.
Are you pleading guilty because you are guilty and for no other reason? Okay, I will accept the plea. Order pre-sentence investigation report to be done by probation parole and send you on June the 23rd. Okay, now he has time to serve now, doesn't he?
He does.
You're in the custody of the jailer and we made arrangement. I've talked to the jail up there. You have your oxygen with you?
No, Your Honor, that's when we had, he has to, it's a machine, so it's at his house and his medicine's at his house.
Well, he needs to go get his medicine. I don't know whether they allow the machine in there or not, but bring the machine with you. They've got a tank of oxygen up there for you. They can use, but if you, how big is the machine?
It's one of the box ones. isn't it?
Like that.
I don't think you'll be able to take that to jail. They'll take care of you when they get up there. They know you're coming and need oxygen.
Yes, sir.
Okay, you go get your medicine and be back down here in 30 minutes. And turn yourself in, okay?
I was going to request, sir, could I get my own transportation, be there at 5 o'clock?
No.
And he gets some meds filled.
You have a prescription to be filled?
Yes, sir.
I'll allow you to turn yourself in up there at the jail at 5 o'clock.
Thank you, Your Honor.
Okay. Okay, let's go to, don't have anyone else here live. Let's go to the Adair County Jail. You can turn your camera on now. Thank you all for your patience. Brandon Anderson, Commonwealth versus Brandon Anderson. This is a pretrial conference. Mr. Coleman Hurt.
I was going to ask to pass this a month. Mr. Hurt and I miscommunicated with each other. He thought that I was offering 3 years on a possession to serve on Mr. Anderson. I was offering 5 years on a trafficking to serve. I guess we both talked past each other, so I'd ask for another pretrial day and negotiate.
Mr. Anderson, evidently your attorney and the Commonwealth miscommunicated with each other, misunderstood each other on a potential plea proposal. So you want to set this for on the 10th?
Yes.
I said the negotiation day for June the 10th here at Burkesville, and then your next court date's on the 25th, okay? Thank you. Thank you very much. Michael Birdwell. For sentencing. Include you on my class. Commonwealth versus Michael Birdwell. 22 CR 004, 22 CR 008, 22 CR 0022. Are you Michael Birdwell?
Yes, sir.
Okay, you're here today for the purpose of sentencing. Have you had an opportunity to look at this pre-sentence investigation report done by probation and parole?
Yes, sir.
Is substantially correct?
Sir.
Okay, Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
On a plea of guilty possession of controlled substance, first degree in case number 22 CR 004, the defendant shall receive a sentence of 1 year to serve on a plea of guilty possession of controlled substance, first degree in 22 CR 008, the defendant shall receive a sentence of 1 year to serve. On a plea of guilty to stalking, first degree in possession of controlled substance, first degree in 22 CR 0022, the defendant shall receive a sentence of 1 year on each to run concurrently for a total of 1 year to serve. The sentences on 22 CR 004, 22 CR 008, and 22 CR 0022 are to run consecutively for a total of 3 years to serve. Okay, the court costs are what?
It's a total of $550 for all three cases.
$550 for all 3 cases. I'll allow you to start paying that at $50 a month, 30 days upon your release. Yes.
I did have a request since Mr. Birdwell is indigent and he's taking time to serve. If the court would consider waiving some of the court costs.
Can we combine the court costs on some? How much would be that? I'll merge the court cost and take the court cost down from 500 and something to 290, if that helped Mr. Birdwell when he got out. So I mean, he can pay it at $30 a month. I know it's hard to get back on your feet sometimes when you get out. So you can make a first payment $30 on 30 days after you get out of jail. Okay.
Thank you.
Okay. Thank you. Douglas Bowe. Douglas Bowe. Commonwealth versus Douglas Bowe, 22 CR 0010. Mr. Bowe, you're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Is it substantially correct?
Yes, sir.
Okay. Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty to assault, third, and tampering with evidence, he shall receive a sentence of 5 years on each charge or run concurrently for a total of 5 years. Court costs him out of $215, and he can start paying that $30 a month for 30 days after he's released from jail. Okay, thank you very much, sir. Paul Bricker. Where's it, Bricker or Bricker? Bricker. Yeah, Commonwealth versus Paul Bricker, 21 CR 00148 for pretrial conference and 22 CR 0048 for arraignment.
Judge, I'm standing in for Mr. Cross. Mr. Cross is in the tank.
The new charge is being a persistent felony offender. Grand jury of Cumberland County has returned an indictment against Mr. Paul Bricker. I charge him being a persistent felony offender, enhancing the committed offense of wanton endangerment. Counselor, you acknowledge the receipt of the indictment, the identified way from the not guilty.
Yes, Judge.
Now, what do you got? Mr. Bricker needs a conference.
Yes, he needs a negotiation day. Mr. Cross will be there. I think we do the same order that we contact and set one up.
Mr. Bricker, Mr. Cross will be in contact with you. They'll get a negotiation day set up, and your next court appearance that will be before your next court appearance. Your court appearance will be on June the 23rd. Okay.
Mr. Bricker will be there to see you next week at the jail.
All right, thank you.
Thank you very much. Charles Brown. Charles Brown. Commonwealth of Kentucky versus Charles Brown. Are you Charles Brown?
Yes, sir.
This is 21 CR 0089 and 22 CR 0034. We're here today for pretrial conference.
Your Honor, this was the Mr. Brown's case and Mrs. Brown's case. They had private counsel who withdrew last month, and the court appointed me at that time. We are still working on trying to get all of the discovery on the original case. The Commonwealth's working on it. We tried to get it from private counsel and.
Who was private counsel?
Mr. Vaughn. Yeah, and I think he's had some health problems. So the Commonwealth, we're working together trying to get the rest
next week.
Okay, we'll have a pretrial you'll have a negotiation for Mr. Brown. Is Christy Brown there? Or is she up? She there yet? Or are you bringing her later?
Yeah, she's here too. Do you want me to bring her up too?
Yes.
No, and Your Honor, we'll be getting conflict
Well,
counsel.
wait, till she gets up here.
All right, there she is.
Okay, are you Christy Brown? Okay, Ms. Brown, they're going to get a conflict counsel. You and Mr. Brown will each have to have a separate attorney to talk, and we'll have that done in negotiation day on the 10th of next month, and your next court appearance is on the 23rd. So the Office of Public Advocacy, when are you going to be in contact with them?
Your Honor, I met with Mr. Brown yesterday. Ms. Brown, I've not met with because of the conflict situation, but I have applied for her a conflict attorney for several weeks now. So hopefully it will be any day that she has an
Who are
attorney.
you going to get for that?
I don't know, Your Honor. They pick them at the office and they don't consult me
So
on it.
Ms. Brown, there'll be another attorney contacting you in just a few days in time for you to talk to the attorney, inform them what the situation is, and then both of you will be involved in negotiations on June the 10th. And the next court date will be on June 23rd. Okay, thank you very much. Melanie Connor. Melanie Connor.
Yes, yeah.
Commonwealth versus Melanie Connor, 20 CR 0033. Are you Melanie Connor? Are you Melanie Connor? You're here for a probation revocation hearing. Is that one of your clients?
Yes, Your Honor. I
Still-
met with Ms. Connor yesterday, and I believe we may have a resolution if the court will allow.
Okay.
She's got a 3-year sentence, Your Honor. And basically for the violation from November the 19th through May the 6th, she had 4 positive tests for methamphetamines.
Yes.
I don't think she's contesting that.
No, she
Okay,
does.
she stipulates to that, so the officer can be released.
We were going to refer her to drug court. If the court will.
Yeah, I'll agree to do a referral, Ms. Connor. Are you willing to try drug court?
Yes.
Okay, I'll do a referral on drug court. They'll be up to interview you concerning that. Officer Burton, is that the reason that you're here?
Yes, Your Honor.
Okay, if you have no other case, you can be released. Thank you for your participation.
Thank you, Your Honor.
Yeah. Alfred Cresilius, they'll be up to interview this class pretty soon. Okay, I just got a few more cases. Alfred Cresilius.
Yes, sir.
This is 22 CR 0033, 22 CR 003, 22 CR 0049, and 21 CR 00136. We have an arraignment. 49. Okay, Mr. C's, you have a right to remain silent. The grand jury of Cumberland County has returned an additional indictment charging with burglary in the 3rd degree and theft and unlawful taking or disposition. More than 1,000, less than 10,000. Counselor, you acknowledge the identity of Mr. Casillas, received the indictment, waive formal reading or including not guilty, observe all pretrial motions.
Yes, Your Honor.
Does Mr. Casillas need to be included in the,
He does, Your Honor. He has 4 cases.
in the 4 cases will all be considered in negotiation on June the 10th. Your next court appearance will be on June the 23rd. I'm signing a reciprocal discovery order, Mr. Casillas, so that they'll give your attorney the information on this last indictment that you got arraigned on today, okay, to help you prepare your defense. So she'll be up there very soon and to prepare for the June 10th negotiation date. Thank you very much.
Thank you.
Yeah, Billy George. Billy George. Twenty-two CR 0045, Commonwealth Kentucky versus Billy George. Mr. George, were you born in 1977?
Yes, sir.
What are the last 4 digits of your social security number?
7446.
Okay. We have an arraignment for you. You have a right to remain silent. Do you have an attorney?
No,
Can you afford an attorney or what's the deal?
no, I can't afford them.
Do what?
I can't afford one, no.
Okay, I'll let you fill out an affidavit. Miss Costello will stand in for Office of Public Advocacy. Miss Costello, you heard Mr. George identify himself.
Yes.
The grand jury of Cumberland County has returned an indictment charging Mr. Billy D. George with possession of controlled substance, failure to maintain insurance, operating motor vehicle under the influence, operating a commercial vehicle while under the influence, improper use of a farm plate, and careless driving. You acknowledge the identity of this gentleman, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order, Mr. George, sit where the Commonwealth will give your attorney the evidence it has in the case to help you prepare for your defense. She'll be up to see you in the next few days, and you'll have a negotiation day on June the 10th at 1 o'clock to negotiate your case to see if you can reach a settlement. And your next court date will be on June the 23rd. Okay?
Thank you, Your Honor.
What kind of bond is this gentleman under?
He has a $15,000 surety bond.
Mr. George, that's not a very high bond.
I'm not from here, I'm from Tennessee.
Are you? Okay, that's probably.
Like, I'm,
5,000, 10% or something.
Yeah, will you come back if I let you out on this thing, Mr. George?
yes, sir, I will.
Okay, now I want you to sign a waiver of extradition. Means that we don't have to send the dog down there to Tennessee to get you. You know what I mean?
Yes, sir.
You agree to waive extradition and come back?
Yes, sir, I will.
I'll do a $5,000 bond at 10%. Do you have somebody that can put $500 up to get you out of jail?
Hopefully, I don't know though.
I'll be communicating with
Well,
you.
he'll be communicating with you, and if you can't make that, she'll get back. We don't have bail bondsmen here, so it won't cost you. Whoever puts the 500 up will get it back if you show up. Okay.
Okay.
Minus 10% or something like it costs $50. Isn't that right? About $50 what it costs them, and so in any event, we'll get a bond order in there, and your attorney will be in contact with you. Okay.
Will that be right now, where I can get somebody to get hold of?
Do what?
I'll be able to get hold of somebody right now for that. If I do.
The jail will most likely let him call.
The jail will let you. Okay.
Yes, sir.
Okay. Thank you.
Thank you, sir.
Bradley Gunter. Bradley Gunter. (21 CR 00152). Are you Bradley Gunter?
Yes, sir.
You're here today on a probation revocation. Are you born in 1987? Born in 1987?
Yes.
What are the last four digits of your social security number?
1687.
Okay, what's the story on Mr. Gunter here, Mr. Stockton?
Let Ms. Costello go first.
Yes, Your Honor, this is a conflict has arisen in Mr. Gunter's case. He's being held in Adair County as well. I've applied for a conflict attorney for him, and they have not been appointed yet, and I apologize to the court. We're struggling to find those. If we could approach and explain the.
Okay.
He's going
I
to,
can't hear you.
I'm sorry, he's gonna be working,
Okay.
yeah, that was it.
Okay. So what do you want to do on the case? Continue it to. Yeah, I'll continue the case to June the 23rd, and I'll set a negotiation date. I'll set a negotiation date, counsel.
Yes, Your
I
Honor.
will set a negotiation date for the 10th if you want to use it.
Oh, yes, thank you, Your
Okay,
Honor.
the
That would-
10th if you want to use it, and then the next will be 23rd. Miss. Charles McCoy, your attorney will be up to see you. Charles McCoy. Charles McCoy.
Yeah. He's coming.
I couldn't hear nothing.
Commonwealth versus Charles McCoy, 22 CR 0044. Are you Charles McCoy?
What was that number again, please?
Are you Charles McCoy?
Yes.
Were you born in 1965?
As far as what I've been told.
Okay, and the last four digits of your social security number, 1873.
Yes, I've been told that was incorrect several years ago, though.
Okay, now, are you represented by an attorney, or do you want me to appoint you attorney?
I have no attorney. I'd like to have some questions first, though.
No, you're not getting, you listen to me, okay?
Okay.
I'm on
I
point.
represented him in district court. Your
Okay,
Honor.
the Office of Public Advocacy is going to represent you. The grand jury of Cumberland County has returned an indictment charging you with fleeing or evading the police in the first degree, 2 counts. Assault to 3rd degree. Failure to maintain insurance on a motor vehicle. Failure to signal. Disregarding a stop sign, reckless driving, no registration plates, expired registration plates, and speeding. Do you understand those charges?
I understand I've been charged with them,
But
yes.
I don't want you to comment. Do you just understand what you're charged with?
I said
or no?
yes.
Okay, thank you. Counselor, do you acknowledge the identity of your client? The receipt of the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, Mr. McCoy, you'll next be for June the 10th for negotiations, and June the 23rd is your next court date. Now, Counselor, you have anything you want to say?
Yes, Your Honor. I would ask the court to consider a lower bond for Mr.
What is
McCoy.
the bond now?
It's 20,000 clerk approved surety.
I think this was an extensive fleeing and evading case alone.
Come on, here's my savior. I'm gonna try to pay to get out of here too.
That they're talking about.
Yeah,
your
we
bond.
were.
They're trying to lower your bond. You'll do that.
Traumatic brain injury.
This was an extensive fleeing and evading case, and then it was assault. Well, sure, I truly think it needs to be evaluated.
I was also going to suggest that and ask.
I'll order an evaluation.
I have a suggestion on the KCPC because I talked to them for a case in Adair County and their weight, of course, is extensive. However, they are allowing them to do outpatient as in, and they can do a secure transport. So they can be transported and taken up there for an evaluation, which is somewhat quicker.
Yeah, I'll sign it on that.
I think Mr. Wright had filed one.
Put a hold on that as far as the bond is concerned until the evaluation. Okay, well, we'll put a hold on that. Okay. On the bond condition. Okay, Mr. McCoy, they're gonna transport you for an evaluation and your attorney will be up there real soon to speak to you, okay?
Okay. When?
Your attorney will come up here and talk to you,
Okay.
and she'll tell you when and all that,
Yeah,
okay?
the 10th will be the negotiation.
What's the chance of me trying to pay something here to get out, you know?
But your attorney will talk to you about that too. We'll see how
Okay.
quick we'll get to the evaluation.
Okay.
Noah Neal.
Work with her number and stuff on it.
I've also,
Noah Neal.
Oh, but you gotta talk to the lawyer, okay?
you don't think her?
Bridget will tell you. Bridget will help you, okay?
Commonwealth versus Noah Neal. Are you Noah Neal?
Yes, sir.
You're here for sentencing?
I believe so.
Yeah, have you had an opportunity to look at the pre-sentence investigation report down by probation parole?
Yeah.
Is it substantially correct?
Yes, sir.
Is there any reason why Mr. Neal should not be sentenced today?
Yes, Your Honor. We, last month, we were here for sentencing and the court was agreeable to a drug court referral. He was referred and accepted today. If the court would allow him to do that.
Well, do we need to modify this?
I don't think the report needs to be modified. It just in lieu of him serving a sentence if the court is okay
well,
with drug court.
we're gonna allow you were interviewed, was he voted in today?
Yes.
So you have to have an orientation, so he'll be released at the orientation.
Yes, Your Honor.
Okay, so they voted you into drug court. They voted you off the island, man. And so they'll come up and do an orientation before you get you into drug court. Okay? I'll go ahead. I'm going to plead guilty to theft and unlawful use. Shall receive a sentence of 5 years. Pretrial diverted for 5 years. Is that right?
That's what it was originally.
And so are we revoking it? I'm not going to revoke the pretrial diversion. I'm going to leave it in place and put a condition that you do drug court. What?
You voided it.
I already voided it last month.
So I have a sentence and probated for third court.
Yeah, so we'll go ahead and sentence to 5 years and probate it to drug court.
Thank you.
I think we froze. He's at class two. Oh, so that's why it froze us.
Straight on. on too. Could you turn the microphone on there to Dare County Jail? Over in the left-hand corner of the screen, there ought to be a place you can turn the microphone. There you go. There you go. Commonwealth versus Gene Parrish, 19 CR 0040, motion for shock probation.
Yes, Your Honor. Your Honor, I filed this motion on behalf of Mr. Parrish. He was, his diversion was voided by this court in February, and then he was sentenced in March to serve a 3-year sentence. At the time, we had presented a plan to the court for a long-term treatment bed. And we would ask, and that's what we're asking the court to do today, to shock probate him into long-term treatment. He has served a total of 118 days on this case, Your Honor. Mr. Parrish is very motivated. I know he's had some opportunities in the past,
What does the
but
Commonwealth say
I'm in employment because he's up for parole in July.
of this year?
They already done a parole plan. And I've had a lot of complaints on Mr. Parrish over the long years. So
Mr. Parrish, you're up, they're already doing a parole plan for you for July. I'm going to take this under consideration, see what the parole board, I think it would be better for you to be on parole and probation.
Your Honor, I would love a chance to go like to rehab. I do long-term treatment. That's what I need. I do need it. And that's what I want in my life. I would.
Hey, you're,
Yeah.
Gene, you hear me?
Yes, yes.
Come over here.
Can you hear me?
Yeah, I can hear you.
You make parole, you can still get you the long term. That's a whole different route. So you ain't gotta be going after that to them. I can still do, I can do something that's same thing.
Okay, well, we'll see what they do in July and see about the thing and they'll try to get you the treatment, okay? Thank you very much.
All right, thank you.
Richard Pitcock. Commonwealth versus Richard Pitcock. We're here for sentencing. Are you Richard Pitcock?
Yes, Your Honor.
1998.
Yes, sir.
Last four numbers of your social security are 88838.
Yes, sir.
Have you looked at this pre-sentence report done by probation? Have you seen that?
Is that for me? Yeah. Yes, Your Honor.
Is it substantially correct, Counselor?
yes, Your Honor, I did not see any corrections.
Okay. Found plea of guilty to wanton endangerment. The defendant shall receive 5 years.
Yes, Your Honor, he had originally had a diversion that was voided by this
Pay
court.
a fine of $500. And what's the court cost?
He still owes $605.
He still owns $605. So you can pay that at $30 a month, 30 days after you get released, okay?
Yes, Your Honor.
Okay, thank you very much.
Right.
Free Sanford. Commonwealth versus Corey Sanford, 22 CR 0036. Mr. Sanford is here for arraignment. Mr. Sanford, were you born in 1990? Last 4 digits, social security number 4109.
Yes, sir.
I have appointed the Office of Public Advocacy to represent you. You have the right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance, first degree heroin, possession of controlled substance, first degree, another controlled substance. Mr. Bailiff, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions, counsel.
Yes, Your Honor.
Negotiation day on the 10th of June, and the next court day is on the 23rd of June. And what's the bond on this gentleman?
15,000 cash. He is a high risk.
Okay. Okay, I won't consider a bond until there's negotiation. sign a reciprocal discovery order. They'll be giving getting the discovery to you, Mr. Sanford, so you can prepare your defense, okay? Thank you very much. Jim A. Webb. Jim A. Webb. Commonwealth of Kentucky versus Jim A. Webb, 21 CR 00017. Mr. Webb, you born in 1987.
Yes, sir.
Last four digits, social security number 8935.
Yes, sir.
Okay, we're here on a probation revocation. What does the Commonwealth have to say? You move to the left a little bit more.
He has a 5-year sentence, include where he's charged with possession of a handgun, convicted felon possession, fleeing and evading. And then on 4/18/22, he was charged in Cumberland County with possession of a firearm by convicted felon, possession of controlled substance, and being a fugitive from another state. I think Mr. Poindexter states he's got a holder from Tennessee, and I believe that's correct.
He has waived extradition to Tennessee, and where he was on probation down there when he entered the plea to this initial charge that was probated here. What we're asking the court to do is to leave him out on probation here while he serves his time in Tennessee. That way the clock keeps going for him on the probation. He's not been convicted of the possession of a convicted firearm by a convicted felon here yet. And he actually has a good defense. He was outside of a shed and the firearm was inside the shed and there were other people present. So I'm not sure what will happen with that charge here, but we would ask to leave him on probation here, Your Honor.
The court, he has not, the basis for the revocation is the new charge. And he'd either have to, I don't think that case went to the grand jury today. So it would be next month at the earliest. So if the court lifts the holder where he can be extradited, that's fine. And I don't know if he'll face charges up here or not. So, or we can hold him and indict him and try him up here.
Is Tennessee going to extradite him?
That's the jail. The jail should be the last answer if he's got a holder on him.
Tennessee got a holder on him at the jail. Is anybody in the jail there? They going to extradite him?
Extradition.
You did sign an extradition.
I signed an extradition 33 days ago.
Tennessee has a holder.
Does Tennessee have a holder on him there at the jail?
Give me just a second. Hey, Wayne.
Which case is it?
Yes, he does. Yes, he does.
Well, what I'm going to do is I'm going to take this under advisement. And if Tennessee wants to come get him, I'll let him go and leave the probation in place here with a holder on it on us from here on a possible violation. Okay. So we'll see if Tennessee will come and get you, Mr. Webb. If they will, I'll let you go. Okay.
Yes, sir. Thank you.
Jimmy W. Webb. Jimmy W. Webb. Jimmy W. Webb.
Oh, Judge.
Oh, Jimmy, don't let them get you mixed up with Jim Webb. They'll take you down in Tennessee.
Yeah, I know it. I don't want to do that, Judge.
Commonwealth versus Jimmy W. Webb, 22 CR 0012. You're here today for sentencing. Have you had an opportunity to look at the probation and parole report?
We went over it.
Okay, Your Honor. Is it substantially correct?
Yes, sir.
Is there any reason this gentleman should not be sentenced today?
No, sir.
Upon a plea of guilty, the Commonwealth, on a plea of guilty possession of controlled substance first degree, the defendant shall receive 2 years to serve. The sentence should run consecutively to 19 CR 0023 and 21 CR 0067, in which the defendant has stipulated revocation. Court cost amount how much?
$195.
Court cost amount $195. I'm gonna put that off till 30 days after he gets out of jail and do that at $30 a month.
Yes, sir.
Okay, thank you very much.
That's all I had. Can I be excused?
Sure, absolutely.
Thanks, sir.
Andrew Weiss, did you get an opportunity to look at that book I gave you?
Not yet.
Okay,
I
okay,
have it on my dresser.
okay. Andrew Weiss. Tom Ward versus Andrew Weiss, 22 CR 0011 and 21 CR 00120. Are you Andrew Weiss?
Yes, sir.
You were here for a pretrial conference.
Yes, sir.
You'll have an agreement?
We do.
What kind of agreement is
It
it?
is a felony plea.
Okay. A motion has been tendered, sir. It says you wish to enter a plea today. Is that correct?
Sir.
Are you currently under the influence of drugs or alcohol?
Sir.
This plea freely and voluntarily given.
Yes, sir.
Are you the same person named in indictments 22 CR 0011 and 21 CR 00120?
Sir.
Is your judgment impaired today in any way?
No, sir.
You had plenty of time to discuss this matter with your attorney, and are you fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. I'm going to go over those rights. And at the end of these right list, I'll ask you if you understand them. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your own behalf and have a process issued to compel their attendance, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. You understand, by entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any sentence allowed within the range by law. If prior to any sentencing or accepting the recommendation, I will read a pre-sentence investigation report done by probation and parole. In the event that I do not accept the recommendation of the Commonwealth and impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Ms. Gordon Anderson, what is the recommendation?
On a plea of guilty to trafficking in a controlled substance, first degree, greater than 2 grams of methamphetamine in case number 21 CR 120, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to trafficking in a controlled substance, first degree, less than 2 grams of methamphetamine in case number 22 CR 11, the defendant shall receive a sentence of 5 years. These two sentences are to run concurrently for a total of 5 years to serve. The Commonwealth will oppose probation. Defendant shall pay court costs at the discretion of the court. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth of Kentucky.
Is that the way you understood the agreement, sir?
Yes, sir.
Are you entering a guilty plea because you are guilty and for no other reason?
Yes, sir.
Okay. Knowing your constitutional rights, read to, is it still your desire to give up those rights, enter a plea, and allow the court to fix your punishment as permitted by law? You understand that any future convictions of felonies could be enhanced as far as penalty under persistent felony offender law. Do you understand that?
Yes, sir.
Hold that up there.
Mr. Weiss, can you, I don't,
Bring it over here.
yeah, I think it might be.
I don't know whether I'm any closer. Now, I've got a document here that purports to have your signature on it, sir.
Yes, sir. I signed it this morning.
Okay. I'll accept the agreement order pre-sentence investigation report done by probation and parole. Have a sentencing on June the 23rd. Okay.
Thank you, sir.
Okay, Tyler Wright. Another satisfied customer. Tyler Wright. Commonwealth Kentucky versus Tyler Wright, 20 CR 0056. Are you Tyler Wright?
Yes, sir.
Mr. Wright, you're here on a pretrial diversion revocation. Were you born in 1989?
Yes, sir.
4-digit social security number 7662.
Yes.
What do you have, Mr. Stockton?
Gunner, this is our motion to revoke. Officer Gunner had asked Mr. Wright to turn himself in. I think there may have been some confusion. He turned himself in later. He might want to explain what happened. But we're just asking for a sanction. He had a positive marijuana test and he was charged with possession of marijuana. And are you having him going to the SSC or anything, Mr. Garner? I was gonna ask him to explain to the court what happened, and ultimately he did turn himself in, is my understanding.
Yeah, he did, and he does stipulate to those violations, and we're in agreements with the sanction.
What would the sanction be? Go, come over behind them.
Your Honor, I haven't gotten him lined up with SSC yet, but if he's not revoked today, then I will be doing that based off of the admission to the use of methamphetamine and marijuana.
I think Mr. Stoffer was okay with him being released today. Is that still the case?
That's all right, but whenever he wants to have it in court.
When does he have to go to the SS?
The SSC is there today. She's only there on, it'd be next Wednesday, I believe, is when next appointment time for.
Okay, well, we'll make him an appointment for next Wednesday and I'll let him out of jail in time to go to that appointment. And this time that you've been in will be a sanction. I'm not going to revoke you, Mr. Wright. Give you an opportunity, get you an opportunity to go up there, get lined up with those people and cooperate with them. You can be a free man the rest of summer. You understand what I'm saying?
Sir.
We'll release you next Wednesday in time to go to the appointment. You got street clothes up there with you?
I do.
Well, that'll give you time to clean up and put your street clothes on and get somebody to come up there and pick you up after the appointment. Okay?
All right. Thank you, Your Honor.
Do we have anybody else there at the jail?
No, sir, that's it.
Okay, well, thank you for your cooperation. You're released. Is there anyone
Thank
else-
you.
Anyone else here in the courtroom? If not, Cumberland Circuit Court is in recess till 1 o'clock.
Yes. Shane Caps and we're gonna do whatever photos on there. I'll email them.
Yeah, Shane Caps did not show up from LaRue County, so we'll just need to do it. What was the deal with him?
It was a shock motion that I filed, Your Honor.
We have that last file.
Well, let's do a transportation order on it.
Okay.
And we'll bring him down on the 23rd.
Thank you, Your Honor. Think on that motion, Your Honor, I filed it within the time limits, but I think we maybe pass this now to it.
Well, I'll just keep it under consideration, okay?
Thank you, Your Honor.
Okay. Is anybody watching Lincoln Lawyer? Are you watching Lincoln Lawyer on?
Okay, we're right here.
When you say that they gotta go do corrective work or anything.
Anybody from the county attorney's office here? Was told that they're gonna submit agreed orders on everything. Is that correct? I think county attorney has COVID. So I don't think, hope, wish him well, but I don't think anybody wants to make an appearance over here today. Civil docket. Commonwealth Kentucky versus Carl Spears Jr. and others.
Good afternoon, Your Honor. It's Keith Upchurch.
Okay, Mr. Upchurch, you want to turn your camera on?
Afternoon, Your Honor.
Whoa.
Sorry, Your Honor.
Sorry, Your Honor. Mr. Upchurch and I had a conversation. I don't think.
Can you hear him, Mr. Upchurch?
Yes, sir, I can. Yes, sir.
Your Honor, we had a conversation if it would be acceptable to the court. We were looking for a trial date after the first of the year. We would like to tender an agreed order to the court with more of a scheduling order once we establish a date for the trial, Your Honor.
But is it all discovery been finished? Everything needs to be done?
No,
Your Honor, the situation in this case is Mr. Judd had an expert that retired on him, and that's why the substantial delay in this case. He's going to have to get a new expert, and he's in the process, and he tells me as soon as he do that, we'll have to redo our discovery and everything.
Well, there's no reason to set a date until you get the discovery finished. And my trial orders usually require one to certify that they finished all the discovery and depositions are finished like that. So y'all just keep me informed. When do you think you might have a expert?
Your Honor, we have retained someone, but I'm at their mercy, and I was told about 2 months this week. So.
Okay, well, I'll just pass this on the docket. Y'all can redocket it when you get a little more information with the target of having your expert in place and getting something started in a couple of months. Okay.
Yes, Your Honor. Thank you.
Okay, thank you very much.
Thank you, Judge.
Yeah, Teresa Morgan versus Cumberland Valley Manor, Inc. Hello.
Good afternoon, Your Honor.
Hello.
Rebecca Schaefer on behalf of the defendant, Cumberland Valley Manor. Good afternoon, Your Honor. Heather Warren on behalf of the plaintiff.
Okay. Okay, I've taken an opportunity to read the plaintiff's motion. I still haven't ruled, I guess, on the pending motions on whether or not what sort of entity Cumberland Valley Manor is exactly, and whether they have some immunity sort of situation. Have y'all both completely briefed that?
Yes, Your Honor.
Okay, well, I'm still having a little problem comparing it with some other cases because of the way of the articles of incorporation and things were done. You know, I really, I'm struggling with that. I told you earlier that sovereign immunity issues are not my great strength. Sometimes you get the results that have happened mixed up with the sovereign immunity and what you think ought to be, not what is sometimes. So now I've read your motion here, and the only thing I can say is that if I completely ruled on your motion, anybody y'all's suit would have to be shut down because the level. Do you get this kind of discovery in other courts, judges that are more experienced, these medical marijuana? Do they sign orders to require the defendant to do all these things?
Yes, Your Honor. Every document that's been requested has been produced by attorneys at the firm in trials on nursing home abuse and neglect cases. These are not documents.
Well, I could tell this wasn't your first rodeo. Whoever did this motion here wasn't something that anybody just got up and free-handed there. I'm sure they got complete seminars, some places that do those things. But it's pretty onerous, you know, what you're requesting. And some of the relevance of some of it, I don't really understand. I would like for you to pare it down some and tell me what you really think is necessary and what's not boilerplate, what's relevant to this case. I can see how you would need some of the financial records to see asset allocation in the entity about staffing, their staffing compared to other places. I don't know whether it's relevant really to find out how much each of the staff's making or something, because every market would be different. You know, what you might be able to hire a really proficient nurse's aide or I guess they call them CNAs or that sort of thing here versus what you would get in Lexington. I don't know whether that's really relevant, but I'd like for you to try to hone it down rather than me to rule on it now to do something, you know, that I might regret doing or that you don't really need. The other thing is, what was the other issue besides the discovery? There was you wanted to extend the deadlines?
And we have no objection to that, Your Honor. I think that they've had some trouble getting some medical bills, and so certainly think they're entitled, not from us, but
From the Cumberland County, there was some kind of issue in the Cumberland County Hospital, correct?
Yes, Your Honor, we've requested records and we've had kind of a delay in receiving.
There's something about some of the records had been lost or something, or?
Perhaps, Your Honor, we're hopeful that that issue can maybe be resolved.
Is that where the decedent passed at the Cumberland County Hospital, had been transferred up there?
Yes, Your Honor.
What else?
Well, Your Honor, I think we don't have any objection to that. We can kind of just suspend the discovery deadline at this point. We don't have a trial date or anything like that. And then we have been trying to take the deposition of their physician expert for a while now.
I saw that. It'd been scheduled a couple of times, right?
Yeah, and he keeps on going out of town every time we try to fly out there and take it. So I think we're going to try to get that.
Where is he located?
He's in Boston.
Well, I might be available to go up there, you know.
He spends part of the year in Martha's Vineyard as well, Your Honor.
It's tough duty, yeah. I get on one of those little swans in the pond there, little paddle boats and go around a bit. You need me to do something to compel him?
I think that we can probably work it out. You know, it's been rescheduled twice now. We'll give it a third shot, and if he still doesn't show up, then we might get your help on it. But I think
it's not that he's not unwilling to be deposed. The issue has just been the location. He's always offered, you know, I'm available. You know, I'm here now. I'm not in Boston. If you'd like to take my deposition by video. The technology that's available now via Zoom conference, which we use frequently in these cases for our experts, he's offered that. So it's not that he's unwilling to be.
Well, are you going to do him? Will you do him twice? Will you do him once for discovery purposes and then I guess you'll bring him for trial? Is that correct?
Your Honor, and that's exactly why we wanted to be able to take his deposition in person, because it's our understanding that plaintiff's counsel is planning on presenting him live at trial. So certainly we'd like the benefit of being able to see how he's going to.
Well, I would like to have him here, but it would be a rare occurrence when you get a Boston doctor to come to Berksville. Now, they might do it, you know. Well, I'll just leave that part of it in abeyance. And is there anybody in the business that does mediation or anything that would be good with helping me take a look at these discovery issues to see what would be reasonable?
Well, Your Honor, I think, you know, we've worked on several cases together with Ms. Schiffer's firm, and we've worked on these, trying to resolve these specific discovery issues. We've kind of come to an impasse, which is why we're before the court now, but we've attempted to come to some resolution on these issues. I am happy to pare down at the court's request some of these issues. We do believe they are all relevant.
All of them, I mean,
well, and Your Honor,
at least they're probative, you know.
We filed a response and objection to their motion to compel. I don't know if you just received it. Okay.
Yeah.
And you know, we just received a list from them yesterday. They want 291 personnel files. So if you can imagine the amount of time that it would take a small facility like this isn't a big corporation, it's a nonprofit singular facility.
I mean, what I would try to look at is anybody that was involved in her care.
That's exactly what the list is, Your Honor. It is.
There are 291 people involved in her care. I don't believe that.
Charted on her record. Their names are in her medical record.
Because she was there for 4 years, Your Honor.
Oh, okay.
But however, their focus, I've already deposed their nurse expert, and she's testified very clearly as to what her criticisms are, and they are very narrow issues. And so it seems like they could identify the staff that were involved with the care for those narrow issues.
You think you could do that?
We can, Your Honor, we'd be happy to.
Why don't you try to do that to see if you can do it without failing to represent your client. The other thing is about the confidentiality of these incident reports. I'm a little confused about what the state of the law is on that. It seems like that the state Supreme Court at least equivocated a little bit. What do you think the state of the law is? I mean, I understand why they want to keep these reports confidential, because if you didn't keep them confidential, there would be incentive not to report and take care of people. Do you believe they're all discoverable, or?
Well, Your Honor, our position is that they are all privileged and they're not
Yeah, I know
discoverable.
that's your position.
So with regard to the investigations, plaintiff's counsel, actually, we were previously here at the start of when this case was first filed on an initial motion to compel, and plaintiff's counsel conceded that yes, they agreed the actual investigations and follow-up were confidential, privileged, those should not be produced. So then we're left with the actual just incident reports, like the initial report when the incident happens. And I think that under the
which might be more damaging than the ultimate investigation was. You know, if someone was.
Usually it just has the factual information for the most part. But I think that with the recent amendment to
I saw that.
the KRS 311-377 with regard to the
And you
peer
wanted to
review.
retroactive that kind of thing, right?
And so far, every court has agreed that it's retroactive. I don't believe that any court has made a determination that it's not.
And what were the limitations on the change? The General Assembly appeared to try to protect the nursing home a little bit on those, right?
With regard to peer review, it's a straight out, like anything that is done by the peer review committees or created for them is privileged now.
And do you agree or not agree with it?
Well, Your Honor, the problem is here what these reports are created for and who they're created at the behest of, not necessarily the applicability of this statute, because if they're not created for this purpose and they're not created at the
If they don't have a
behest
peer
of
review
quality-
process in, and those not specifically created, but they're trying to use that to cover incident reports, right?
Your Honor,
So
there is a case out of Kentucky in 2020. The case is Henderson County Healthcare.
You cited it, I think, yeah.
Yes, Your Honor. They say take a case by case approach. In this case, the nurse, the director of nursing and the assistant director of nursing testified that the nurses actually create these reports, and these reports are required to be created by law. Then they send them through perhaps maybe the quality assurance team, but they're not created at the behest of the quality assurance team. They're created by requirement of the law
What
that
law?
these reports are created.
Well, have you had experience with other nursing homes that keep those separated?
Your Honor, the law is 902 KAR 20048, and we have received these reports in
That's
discussion.
an administrative regulation, right?
Yes, it is. Yes, and they require that written reports are created
For what
incidents.
purpose?
Every nursing home must keep a written report of any incident or accident involving a patient, including medication errors or drug reactions. Visitor or staff shall be made and signed by the administrator or nursing supervisor and any staff member who witnessed the incident. The report shall be filed in an incident file.
Okay, is it your experience that incident files are different than peer review files?
Your Honor, if they're not created, if these incident files are not created.
I know what your theory is if they were created as a part of another process or another requirement under the administrative regulations, then they're a different document. Even if it's the same document, they're a different document because the purpose of their creation is what defines whether they go under the peer review, is what you're saying, right?
Yes, if they're created.
Well, I'm asking you what your experience is with other nursing homes, whether they have two separate files or do they have a duality of purpose with these two documents, or what's the deal? And if that's the deal, are those subject to discovery that are created under that regulation?
Your Honor, I'm not sure that there would be a duality of documents. I think that these documents that are created by the nursing staff under the regs are the documents that we're seeking.
Well, I'm sure that's what you're seeking, but what if, what I'm asking procedurally inside the institution, if they create that document under that administrative regulation, is it the other purpose of it is to meet with their peer review? So do they keep them separate from each other, or they mark them for both purposes? I mean, you're bound to run into this before, that people use this peer review legislation that some tremendous lobbyist was able to get passed to protect those records from discovery that are created under this administrative regulation. I don't know. I would be interested in seeing what the practice is in the industry where they have, I would doubt very seriously if they thought they could take these reports, incident reports, and protect those incident reports by putting them through the peer review thing, that 100% of the institutions aren't doing that. You understand what I mean? I mean, they'd be foolish not to do that.
Certainly they're claiming it.
They're claiming it. So I wonder if you have an incident where someone has discovered any of these incident reports under that administrative regulation that they've been able to get and overcome this claim.
Not that I know of, Your Honor.
I believe that they've been ordered in the past, Your Honor.
But I'd like to see what some other courts have done and see if there's any law on that. Because, you know, if I was representing a nursing home and I saw that administrative regulation, I would say, well, we're going to do that, but it's a part of our peer review process. And that's what you're saying.
Yes, the duality of purpose, Your Honor.
Yeah.
It's just like with regard to a HIPAA privilege or confidentiality, there's lots of regulations and statutes that require us to keep my client to keep records about the various residents, the facility, and their medical records. And so, yes, they're required by regulation, but they are also privileged under the HIPAA statute.
Unless you redact them.
Well, and it depends on the record. Yeah.
Yeah, I
just
mean,
have
you
to
can
protect
redact them
the
as long as
confidentiality.
they aren't patient specific and identified. You could look at those.
Well, as the director of nursing and the assistant director of nursing testified in this case, if they're created in the normal course of business pursuant to this regulation, then funneled through quality assurance in order to protect them.
They testify to that?
They testified that there is a nurse, a wing nurse that creates incident reports for falls and accidents, and then a separate nurse who creates incident reports regarding pressure sores and pressure ulcers.
And they said that they were funneled through this peer review thing. They testified to that.
They testified that they speak about them in morning meeting.
They did not.
Is that the peer review meeting that you're talking about, or what is?
Well, they have a quality assurance committee where these documents are reviewed. And so it's kind of like a chicken versus egg, because they were creating incident reports and using them in quality committees before the regulation was put into place.
Which regulation are you talking about?
The regulation with regard to them being required to create incident reports.
Yeah.
So this is something just as a industry standard for quality assurance purposes. Incident reports are fairly common. Kentucky happens to have this regulation that also requires that they create incident reports.
Which is separate from the statutory
Correct.
situation as far as the peer review. So I wonder if this statute does protect these other things. I mean, do you have a case law on that?
Well, and Your Honor,
I'd rather not return the, I'd rather not, be the person that decides and gets the case decided. You think there is a case on this?
There is not a case on it yet. We have made the argument to trial courts, and the trial courts have agreed with us. I don't know that the orders specifically addressed that. I can look for those cases. I can send you copies of those trial orders if you think that might be helpful.
Your Honor, the case that we cited, the Henderson County Healthcare Corporation versus Wilson, does speak to these types of documents. They say additionally, incident, accident reports, nurse consultant reports, mock surveys are generated outside the committee and made in the ordinary course of business. And in some cases, they comply with the state regulations. These are the precise documents that they're talking about being created outside the behest of the quality assurance team. Then
how do you know they're created outside the behest? What if they were a duality of purpose, like she's talking about, like that the peer review group says, we want these done, and we're also going to do them because of that administrative regulation. It's hard to divide those two things out.
Well, I think that the testimony of the assistant DON and the DON would clarify that issue in saying that these nurses are creating these reports because they're required to do so, not by the quality assurance team, but by law. They're required to do so.
Well, do you have a case where anybody discovered those?
discovered incident reports?
Yeah.
I believe that they've been ordered in the past, Your Honor. I do.
Well, I don't know. I don't know if they are successful in protecting them, it's say it's because the reason they're doing it is because of peer review, and that administrative regulation was issued under the authority of what statute, you know? That's important to me. If it was issued under the authority, every administrative regulation is issued under the authority of a statute, as I remember. You don't, I mean.
And Your Honor, I believe that Plaintiff's counsel may be kind of conflating the two issues because in the Henderson case, they did not make a claim of peer review privilege. They only made a claim of quality assurance under a federal statute. And so the court did not even address the Kentucky peer review privilege in that case.
Okay, well, I understand what your arguments are. So if y'all want to feather that out a little bit, and if you can find anything else to help me on that, I'd appreciate it. So I've got remaining out here this sovereign immunity thing. I'll read the thing. On occasion, I talk to my fellow judges that are in areas that would probably have more of these things than we do because we don't have a lot of cases. I mean, a lot of our people that, I had COVID a few weeks ago and I was very pleased with kind of treatment I got at the local hospital, but I would think that they do even put people on respirators, but quite frequently when people go really bad, they take them out of here to a hospital with a higher level of care. So, and I think that's where you get a lot of the malpractice cases sometimes is when you get to hospitals with more surgery going on or more, so we don't get a lot of, I think since I've been here, I've had one medical malpractice case in 10 years at the hospital. Can you remember any more than one or two? One or two. I don't know if we've ever had a case at the nursing home since I've been here. Maybe there has been.
Your Honor, we just actually received an order in Metcalfe County. And
Judge Alexander.
Yep, exactly. Judge Alexander, and he actually granted the same motion
I know
for governmental immunity, and it was against opposing counsel. And so if it would be, to the extent it may be helpful, I can.
Well, I'm gonna get a copy of that. And I also want to see their articles of incorporation and see how deeply he got into that.
Your Honor, this is the precise case that was cited by the plaintiffs and relied upon by the plaintiffs in this case that was relied upon in Metcalfe County. It was the same facility, the same articles of organization that Judge Alexander reviewed, that was reviewed by the Court of Appeals in Roberts' case. It's our position that they are distinguishable.
Yeah, and although you didn't prevail in that, the case law was the same, the authority was the same, right?
The Roberts case was in Metcalfe County.
Yeah.
It was involving that facility. So,
So it's a consistent ruling that it is entitled to immunity.
He followed the ruling of the Court of Appeals in Roberts.
Yeah, okay, now, and I want to give me one more bite at the apple here. How do you think that the articles of incorporation over there are different than the articles of incorporation here at Cumberland Valley Manor? Tell me real briefly how you think they're different.
Sure, Your Honor, and it goes directly to that functional level of direction that we briefed very thoroughly, the new case law that deals with actually expounding upon what functional level of direction is the county exercising over that agency that the court is looking at. It's the common analysis. It's been parsed out further by the Supreme Court in recent cases. They're not just looking at the plain language of the articles of incorporation. They're actually looking at what is the county doing to direct this agency.
And what did they do in Metcalfe County?
In Metcalfe County, there were actual members of the fiscal court on the board of directors.
Ex officio kind of, right? Or by appointment, which one?
Your Honor, I don't know that the articles actually enumerated a process of appointment or election to that board, but there were members of the fiscal court that were acting
as board members.
Yes.
What would you say to that?
Well, and Your Honor, Judge Alexander did not find that to be a dispositive with regard to his decision on it. He looked at the fact that if the facility in Metcalfe County were to be dissolved, the funds would go back to the county. Same thing with Cumberland Valley Manor. He also looked at who created the facility. It was Metcalfe County. Same thing with Cumberland Valley Manor. It was created by the county. And with regard to the members of the board for Cumberland Valley Manor, they are also volunteer unpaid members who under the requirements of the bylaws, they still have to be citizens of the county. So you can't just have, I mean, I think it's
How are
maybe
they
a broader
appointed?
scope.
How are they appointed?
They're voted by
By the
members.
members?
Mhm.
Yeah. I knew that at one time. I think our hospital board does the same thing. They have shares that they sold or something, their people contributed and that sort of thing. I don't
And that's distinguishable from the Roberts case. That's not the same process. That's-
What do they do in Metcalfe County? The county government appoints all the members of the board.
The members of the board of directors are members of the fiscal court.
All of
These-
them?
No,
So
they're
you
not.
don't, I mean, if you don't remember what the appointment process, I'm not gonna hold you to it because
Sure,
I would
don't
doubt
think
very
the
seriously
Roberts-
if they were completely the same. I'm sure there are other board members that are selected in some process. But I can see how there would be a difference if they were selected by a process like appointed by the county judge, executive, approved by the fiscal court, and that sort of thing, rather than by people who are stockholders or shareholders or that sort of thing.
Certainly, Your Honor, and I think another important distinguishing factor in this case from the others, the administrator in this case, Paul, I believe his last name is Shepherd, testified that he is actually reporting to the board of directors, and the county government, the county officials are never involved in the meetings.
Were
with the
they in
board of
Metcalfe
directors.
County?
Yes, Your Honor, they.
Well, I mean, they were there, they were members of both, but it doesn't necessarily mean that when they were on their board, they were sitting as their official capacities as magistrates. There might not just have been any conflict between them being there. Might have been an unwritten agreement that they were going to be represented there. So, I mean, you can have a magistrate be on a lot of different things. It doesn't mean they're sitting in that capacity. Ultra virus or whatever they used to call it. I don't remember what they used to call it. Okay, well, thank y'all. Is everything covered in these briefs that you filed
Well, Your
on
Honor,
this
we've
issue?
actually resolved some of the issues in the motion to compel, and I think with the personnel and staffing records, we did produce a list with each person who charted on our client's record, but we would be willing to reduce that down to the final year of her residency.
Would that be
The
helpful?
number of-
It depends, it just depends on the number, Your Honor. I mean, if it's still, 80 people, I think that that's still, because they're having to go out and look through storage units to try to find these personnel files. So I think it just depends on what the number ends up being.
I don't think it's unreasonable if we can get over that issue to tell them to cut it back to a year. I think that's reasonable. If they have to look through those, what would be the other issue?
that are still remaining. There were daily census reports they were only produced, I think 11 months of them were missing at least 1 month from 2014. We also asked.
On whether she was present or not, or whether other people, or what the total census number, what they were there.
Daily census
So you're looking
reports.
at that as an understaffing issue,
It goes to the plaintiff's claim. Yes,
understaffing.
yes, and that's the same, for the same reason that we asked for different payroll records, employee sign-in sheets, work schedules, time card sheets. It's not to look at what their.
You'll do
their
that for 1 year,
compensation
for
is.
1 year?
Maybe.
We've provided that with regard to the last year of her residency, which is the time period that their experts have criticisms.
Well, let's agree, if you will agree to do the 1 year thing, we can cut that down and they'll make sure they provide everybody that charted and all the records, payroll records, everything to see what staffing level there was during that last year.
Okay.
It would be hard to make things before that exactly relevant to, I think, the problem that she ultimately succumbed to.
Okay, so for 1 year, the payroll records, time cards and sheets, daily census reports.
Right.
Okay, and then as far as clinical info, Your Honor, I think Your Honor would like briefing on that issue of the privilege of quality assurance versus.
Yeah,
the
I
statute.
think I definitely want to look at that to see if they run everything through this peer review thing, whether it protects it and the administrative regulation, what statute was, if we find out it was promulgated under the same statute, that's going to have weight with me because the General Assembly came back in and gave certain protection to that information, which would and relate back to the administrator. I mean, I don't know who's getting that for what purpose. It might be for the purpose of peer review. And if not, I don't understand why it's not completely discoverable. If they have to create and keep a separate file, or they can have duality of purpose, it might open those files up. You know, I don't know, but whatever it does, I would limit it to a year.
Okay.
You know, whatever it does.
Okay, and then the last kind of broad scope of documents that we were missing was the financial documents.
Well, okay, what's the relevance of the financial documents to see if they were cutting back? Because, see, I don't think it matters why they were cutting back. I think the staffing levels will speak for themselves. That's what you're looking at, where they had adequate staff to provide the services. And you also talked in the motion that they were doing some high intensity sort of services that maybe should have been beyond the scope of what this nursing home or rehab facility should be doing, and that would have consumed more staff time. Is that what you're getting to on that?
Certainly, the higher acuity patients,
Right.
not matching the
Yeah.
staffing levels to
Yeah.
meet their needs. But Your Honor, the feasibility is the issue with the budget. When you.
Well, you want to shut it down? Is that what you're trying to do? I don't know. Sounds, I don't know what they're, I mean, I don't know what they're, it doesn't matter why they're not staffing it to me. I mean, if it was a financial reason or whether it was a negligible reason or something like that, I don't know. I just don't, if they weren't staffing, they're supposed to staff it properly. They're supposed to meet all standards. And it's irrelevant why they weren't doing that. I mean, if I were a member of the jury, I don't really think the jury should be influenced by the fact that this is a poor community and they didn't have enough money to staff it any higher. I can't see how that would be to your advantage.
Well, Your Honor, I think if a juror could have the information to know that it was feasible for them to have the appropriate amount of staff, but because of the priorities of the operation and management of the facility, they were not doing that, maybe allocating funds elsewhere, diverting funds elsewhere.
Well, you obviously don't know the financial situation of most local medical facilities in rural Kentucky, which I happen to know by virtue of my previous job. And I would say they're not got buckets of money sitting around, because everybody in there is they probably have 2 private pay patients in most nursing homes, and everybody else is Medicaid, right?
Yes, Your Honor, the arguments being made by plaintiff's counsel are the ones that are traditionally made for for-profit ventures.
Yeah.
And so the argument that there's funds being diverted to shareholders or for profit.
Yeah, I mean, what are they going to do with the money? I mean, because they have to make a full report of what their cost is in order to get the reimbursement level that they get from Medicaid and maybe Medicare if they got some probably doctors things going on, right?
Right, and with it being county created, nonprofit, there is no place for that money to go.
Well, I will tell you what I would do. It would satisfy me somewhat if there was some sort of a deposition taken to see if there had been any money ever transferred out of that for any other, out of that the nursing home facility for any other purpose, or whether they have applied all of it to what they have. Now, the other thing could be is if you look at if there's any other way that the salaries or management fees or anything are out of proportion to what other people might be doing. I mean, I just can't imagine that would be.
And there was no management company, Your Honor.
Yeah, well, that kind of takes care of that. I would look at the salaries of the administrators. That's probably discoverable.
We can, and I think that we can provide the salary of the administrator.
Yeah, I would look at, I would let you look at the salaries of all of them and keep it only to counsel until you get an opportunity to confidentiality of that. So you could analyze whether or not there's somewhere where there's leakage of funds from this facility that you believe that you could prove could have been applied to staffing it at a higher level. I think that's fair to do that.
And Your Honor, to that end, I would ask, just because it's a nonprofit, 501c3, doesn't mean that there's a corporate negligence claim in this case, of course. So that doesn't mean that there's not a negligent misuse of funds or operational priority that doesn't, go to a.
Well, I mean, that's the reason you can look at these things.
So I guess, Your Honor, it sounds like plaintiff's counsel is accusing the volunteer board of the Cumberland Valley Manor of
Not yet, because she doesn't have, you haven't given me proof to do that yet. I won't think you have very much to worry about there.
And I point out too, that they're not parties to this lawsuit either. If plaintiff's counsel truly believed that there was some sort of embezzlement going on, they have not made that allegation, nor have they.
Well, I think that it'll be self-evident. I have no way to know, but I think when you see the salary schedules and other things of everybody involved, it'll be self-evident that, you know, they're like a lot of other facilities in rural areas. A lot of them close. You know, a lot of these hospitals, I mean, you just go to Salina, Tennessee, down here, our neighboring county down here, and their entire hospital closed down there, and they made every effort to get it back open, but they can't. They don't have enough, you know, because they don't have no industry with private pay. Very few people are private pay, and with the not to be the American Health Care Act, I used to get chastised for calling it Obamacare, which is not a negative term in my opinion. If I was Obama, I'd want them to call it Obamacare. You know what I'm saying? So, President Obama.
And just to respond, Your Honor, I feel like we don't need to make a claim that there's embezzlement in order for this to be relevant.
You're just talking about allocation of resources.
Exactly, and operational priorities of the corporation and the board of directors.
Well,
and it's relevant to that corporate negligence claim. And I understand the court's order, but what counsel has insinuated.
I'm letting you look at their finances for a year, okay? At their finances for a year, to see how much money they brought in, and how they allocated. I don't think that's any problem to me.
So budget for 2013 and 14 and monthly financial reports for 20.
That doesn't bother you if they keep them confidential. I mean, you know, you're not in competition with anybody. It has any proprietary interest.
I think that obviously we have a concern about the overarching nature of this and the whole relevancy of it. I think that with regard to, as I understand it though, the court is ordering the budget for the last year as well as.
Not the last year, the year before her death and while she was confined, one year period before.
The last year that she
And that might be two budgets. I don't know what year she passed, whether it's a fiscal year, whether it's a calendar year. I don't know when the fiscal year started. I don't know those things. But I don't think it's anything to let them take a look at. But I just absolutely cannot fathom that there's enough money down there that the allocation of it had very much discretion, but you might find it does, you know, I don't know.
I think that the last item is just the board of directors minutes. They've objected to providing this to us.
And simply because there is no mention of Ms. York in the minutes, she's not discussed. It's
Well, it goes to allocation of resources, I guess, to see if there's anything in the minutes that would, I can't imagine anything being very damaging in the minutes.
it's more so just a confidentiality concern. So I guess that.
Well, we'll make them seal these. We'll let them have those and they'll seal them. And if they ever come out, we'll know where they came from, and it will not be a good thing.
Would you like for us to draft an agreed protective order?
Well, I would like, yeah, I agree, and we'll let y'all circulate that. So what we're going to do is we're going to take a pretty good look at the institution for a 1 year period prior to her unfortunate passing. Okay. And then and all of that's going to be under a confidentiality order. Then I'm going to come back and look, y'all are going to brief this thing on whether that administrative regulation, what it was promulgated under, and whether you think it applies to peer review sort of things. And then I'm going to take a look at the sovereign immunity situation and reflect upon what my younger and wiser friend, Judge Alexander, did on the case. Okay. Okay. Is there anything else?
I believe that's all, Your Honor. Thank you for your
Well,
time.
thank y'all very much for having patience while I ask these questions, because it was never my area of practice, you know.
I appreciate the person.
If y'all were litigating a murder or something, I'd probably know more about it than y'all would, but I don't. Okay.
We'll leave those to you. Your Honor.
Yeah, okay. Well, have a safe
Thank you very
trip.
much.
Thank you very much. Yes. Okay, Jeffries versus Jeffries. Okay,
Your Honor, this is Miss Jeffries, now Mills, her motion to show cause. We could set out in our motion the amounts that are owed in the pursuant to the divorce decree he was to pay along
where's the
to.
opposing party here?
I don't think he's here. I don't know that he has counsel.
Well, how did you notify him?
The last address that he provided, he was here in court about a year ago in July. There was an order entered. We had filed a motion to show cause at that time. And he had entered an agreement to pay this on a schedule, and he's failed to comply.
Trouble finding this.
I have my copy if you'd like it.
Got all these for today, and they're in this big folder, and they got tabs on them. I read them, but I can't. He was to refinance the debt within 90 days, pay the monthly sum owing until paid in full. Reimburse the petitioner $2,600 before 8/1 and pay $150 toward the attorney's fees. That's the most reasonable attorney fee that I've ever seen anybody do.
I know.
Did I impose that upon you, or was that
No,
voluntary?
I normally ask for a lot more, but in this case, we were wanting to try to put more money toward this debt.
It's commendable that you're willing to work for near nothing. I did that on many occasions, but it wasn't ever intentional.
But it's family also.
Yeah, I said I probably had more pro se work than anybody else, but none of it was intentional. So. And have you written letters to him about his compliance? Who was his previous counselor?
He didn't have an attorney in the divorce. He signed it pro se.
Yeah.
And agreed to pay this. We came to court
Yeah, I
last
remember
July.
that.
He had no counsel and entered this agreement, and he's made 3 payments.
What if he declared bankruptcy? What would you do?
Well, I think that I don't practice bankruptcy law, but it's my understanding that since it was involved in a divorce decree, it's more difficult to get that.
More difficult is the operative word there, as far as its underlying obligation is concerned. Who are the co-signers on this?
Her parents, Mike and Kathy.
Yeah, I know who your parents are, but we went to $500 this time, so
Yes, just for the trouble from the
I
last time.
understand. How big of a stick do you want applied to this if he doesn't? If I order him to do these things?
A pretty strong one, because we made extra efforts to try to work this out on a slower pay schedule last time.
Well, I don't know. I just been on, I guess I've been on here 10 years. I know it seems longer than that to you, but I don't know whether I've ever put anybody in jail for not complying with the settlement agreement. I've done it on child support. Have you ever gotten contempt powers exercised by a court on a settlement agreement before to put somebody in jail for not doing it?
I possibly have. I can't really recall
I
that.
don't think I ever had to. But this order is just as good as any other order. I mean, an order is an order. So you draft me up an order and that follows your motion. Says that and says that he shall appear in this court on June the 23rd to show cause, if any, he should not be held in contempt and sentenced to 6 months in jail. And if he comes with any legitimate financial reason or plan before then, we'll revisit that. But this seems like to me a flagrant disregard for the court's order and authority. And we'll see how that works. Okay.
Okay, thank you. Your Honor.
Okay.
Do you
thank
think that we should have this new order maybe served by the sheriff?
I would definitely think it would be good to serve him personally on that.
We
By the
believe
sheriff.
it's still in this. Is it
Okay.
Greensburg.
Okay.
Thank you, Your Honor. I'll get you an order on that.
Absolutely.
Hopefully tomorrow.
Okay. Watson versus Roach. Do what? Okay, I think that there was an agreed order complying. This was a show cause hearing on a HIPAA waiver. And I think it was signed by the parties and presented to the court. So we'll pass over that. Kazarowski versus Kazarowski. Okay, what do we have here?
Your Honor, this is the respondent's motion to hold plaintiff in contempt, the petitioner, excuse me, in contempt. And we felt the need to go about bringing this to the court's attention because this case has been going on for 3 years now. And the petitioner has not in any way performed under the separation agreement that is in the court's records. My client has not seen any of the $60,000 that was agreed to in the separation agreement. My client has not seen any of his tools that were to be returned to
Wait
him.
just a second. Wait, give me just a second.
Yes, Your Honor.
Did the land sell?
I am unaware if the land is sold or not. No, Your Honor.
Now you represent Ebony, is that right?
Yeah, Craig McLeod on behalf of the petitioner, Your Honor.
Yeah, what do you have to say about this?
Well, Your Honor, I have, may I approach?
Go ahead.
Here's a receipt for $20,000, and I spoke with opposing counsel on this, and he reflected that his client never signed anything. And if you look on the receipt and the separation agreement, the signatures are identical. So that's $20,000 that she's paid in cash as reflected by that receipt. Second, all of the vehicles that were supposed to be titled over to Ms. Kozarowski have not been, none of them have been, with this several issues. The pink Hummer was taken to a Junior Smith shop and the engine removed. So that's the value of that.
Where is she today?
She has voluntarily checked herself into a rehab center in Hopkinsville. She'll be there for 6 months, and I got to speak with her 5 minutes. That's sort of the rule, that she has 5 minutes to speak per week. So I'm very limited on the amount of time that I can spend with her. This is what she gave me today. There's a cargo van that was dropped that, yeah, all these titles, and I've tried to be reasonable on this, but the titles, we just want, if we could get the titles transferred, we could get some of this money. Like I said a minute ago, $20,000 has already been paid.
Do
Ms.
you deny-
Kozrowski.
do you deny you?
I never received a penny.
Did you sign that document?
I didn't sign any document that says anything of the $20,000.
Have you seen the document?
I have seen the document, Your Honor, and you can look at the top here. This is supposed to be his name.
Where is the document?
I apologize.
Original of the document.
I don't have the original.
Your Honor, I've never seen the original. This was shown to me.
Well, where did you get your copy?
From Ms. Kozrowski.
So, I mean, of course, that's not admissible. You know, I mean, you got a copy of something. I wouldn't think it'd be admissible.
I've asked her about the original.
Well, I'm going to tell you, I'm glad that she is, if she's got some kind of drug problem, but you know, what part of the population doesn't have some sort of drug problem? So you tell her to make herself available to be completely deposed about all these issues, about that and about all these other issues. You know, I'm not saying she shouldn't be there, but I have people all the time that get indicted and decide that they need rehab all of a sudden, and it's a 6 month rehab and they can't get out of it. Well, I got news for her. I can get her out of that rehab anytime I want to. I can send an order down there and one of these people and bring her back here. So I've represented difficult clients. I don't know whether you are or not right now, but you know, you need to make arrangements to meet with her more than 5 minutes. And if you can't make arrangements with that organization, I'll get her back up here where you have plenty of time to meet with her.
Absolutely, Your Honor.
Now, as far as it goes, I don't have enough information, but there was real property involved here. Was it in your name also?
Yes, sir.
So you hadn't signed a deed or anything. So you have a certain amount of security. Is there enough assets to protect your client, you think?
Yes, Your Honor. There is
Okay.
enough assets in
Well, that
play.
makes me feel somewhat better. It's a matter of timing and not ultimately whether you'll do something, but you need to talk to your client to tell her that this needs to be resolved. And if there's property to be sold and these titles back and forth, I wouldn't give her a title to anything right now. If she owed me $60,000, I mean, that's crazy. If you sign somebody a title, it's kind of like the person that stole your dog and promised he's going to bring it back or not. Anybody steal your dog will lie to you about whether they're going to bring it back. So I wouldn't give any titles. So I'm going to give you I want to give you 15 days to get complete compliance with information and to set up a deposition. And if y'all have to go down there and set up a deposition, you if she does not comply with this, I want you to redocket this for a contempt order at our June. Is that rain out there? Well, thank goodness. Yeah, something good's happened today.
Yes, Your Honor.
June the 23rd, redocket it. So you got 15 days from today to set up depositions and stuff with her and get all the discovery and information you want. I would suggest that you make a specific discovery demand on counsel here so he doesn't have to wonder about what you want.
Yes, sure.
Can you do that in 10 days or so?
I can, yes, sure.
Okay, do that. And then he'll have maybe 10 days after that. Make it 20 days from today. That'd give him some time to gather the things together.
In rehab for probation.
Yeah.
Probation process.
Yeah. Okay, so she's not voluntarily checked in, then I guess they say she's there under probation parole, so we can get her back up there for that too.
Yes, sure.
Okay, thank you very much.
Thank you so much, Your Honor.
She's in Hopkinsville, so we're gonna have to make a trip.
Scott versus Scott.
Yes, Your Honor. Kelsey Hall here.
Yes.
I'm here for my motion to withdraw.
Surely not.
Yes.
Did you filed a brief on this case, did you?
Yes, I did.
Well, you ought to wait to see whether you prevail or not before you get out of the case, you know. So you've reached an impasse with your client?
Yes, and this is on behalf of myself and Alan Dodd.
Is Miss Capps here? Okay, well, there's no objection. Draft an order if you haven't already. Give your client, here's one right here. I didn't see it. Could you redraft it, send it back to us and give your client 30 days to obtain somebody to enter appearance? And I'll sign it if you do that, okay?
Yeah, all right.
Okay, thank you.
Thank you.
Chambers versus Chambers. Hello.
Allison Henley on behalf of Eric Chambers.
I read the motion last night. The primary, how many children are involved?
We have two children.
Two children. What are their ages?
The youngest just turned 4 on Monday, the oldest is 5.
Yeah, and the exchange point is in Clinton County right now, but you live in Macquarie County, right?
Yes,
And you're wanting, well, why have we chosen Wayne County schools? Except the extraordinary academic situation in Wayne County. Why have we chosen Wayne County?
Well, with respect to the school issue, we have a situation where he was initially going to ask to be named the primary residential custodian. They've been exercising a timeshare where they alternate every other week.
Yeah.
And if the children go to Cumberland County, it's going to be impossible for him to maintain that because of the distance where he lives. It'll be a 2-hour trip, and that wouldn't be in the best interest of the children. Similarly, if the
So,
mother.
I mean, really, it looks, when I read it, I thought, well, that's the reason that I have a reticence on these equal timeshare situations. It's okay when they're babies and they're going back and forth, but then when they want to get in school and they want to be cheerleaders, or they want to play softball, or they want to do soccer, or they want to get involved in the community, is it better to get them somewhere where neither parent has involvement in the school rather than at least one parent? And I think that might be a problem in Wayne County.
Mhm.
You know, is nobody has a home school, you know, not that we should use the word home school and take it out of context. I just think that we are down to the point where we need to find out with these parents, and it's not easy to get to from Macquarie County here. You go the back road, or you go up to Somerset and come, I mean, London, and come across. Which way?
Fastest way for me is through Monticello. So,
Yeah, you go up the old highway 8. The highway that goes like that, you know.
I go up to Burnside and take 90 across through
Yeah.
Monticello.
So she go over, yeah. So you don't go the back road. So.
No.
Yeah, well, that's a pretty nice interchange up there they have now, so you can get down. But I just don't think it's very feasible for the children to go to Wayne County. I just think that if y'all can't reach an agreement, I'm gonna have to decide where the children go to Macquarie County, which is actually one of my favorite counties. I mean, I used to represent Macquarie County in the state senate, and Wayne and Clinton and Cumberland, everything, but there are a lot of sweet, nice people in Macquarie County that I really appreciate. But I guess we're just, what do you have to say, counsel, on this thing?
Your Honor, we are agreeable to working out a time sharing arrangement to allow Mr. Chambers to have as much possible time with these minor children while they remain in the Cumberland County School, where they have bonded and well integrated into the school system and the community.
Yeah, that's a problem, always. But I guess though, if you can't reach an agreement on this, then I'm going to have to decide which school system they go to. And doesn't matter if you can't reach an agreement on them staying in Cumberland County, then no matter how generous a timeshare you have, if he's not willing to agree to that, then I'm going to have to decide which school system they go to. And luckily, it's in the school. We got a little while to develop the case on this thing and see if these people if both of y'all are capable of saying enough nasty things about each other to change my mind that will ultimately damage the children and what they think of you, we can always decide whether it's going to go like that. Unfortunately, that's what happens. I will commend both of you for wanting the children. It's refreshing to see two parents, and I think the children are lucky to have parents that are willing to fight for their continued relationship with them. So I guess y'all will just have to take some proof. Does the commissioner have a conflict in this case?
Not that I'm aware of, Your Honor.
Yeah, well, he has had some health issues. I understand he's got some surgery going on. I'd like to refer this case to the commissioner for, I think you get more immediate hearings from the commissioner to make a determination on with whom the children should reside when school starts back up, and let everybody just take the longest pole they have and see who knocks the apple off the tree. And if you get it to him now, we ought to be able to have a decision way before school starts. So that, you say 4 and 6, did you say, or?
4 and 5.
4 and 5,
The oldest
little
one
boys,
turns
little girls, what?
Yeah, the oldest is a girl. She'll turn 6 in November. The youngest is a boy. He just turned 4.
And Your Honor, I'd also like to make the point that the children have lived the majority of their life in Cumberland County.
Well, I mean, that's stuff that you bring up. I understand that. But the commissioner will listen to all that sort of stuff, and he's really very good at this. But now you're just getting to the point right now with a 6-year-old where they want to be playing t-ball and coach pitch and all that kind of stuff. And then before you know it, they'll be on a traveling team and you won't have any life whatsoever by driving them here and there and everything. So, I mean, if you can work this out, it would be good, but I understand that everybody wants the children to go to school that they're most proximate, but Wayne County is not going to be the answer to it. So, I mean, the children are going to have to, I'm going to have to do the Solomon bit, see if it works, may not work. If it doesn't, I guess we'll just whack the babies. So.
I understand. So I guess as a formality, do we need to amend and do another motion to see?
Yeah,
who's
both
named
of you need to
primary?
request to be primary,
Okay.
primary residential, or you can do an agreed order if you want to. It just says that you appeared before the court here and it appears that there's no resolution and both parties agree that they're going to proceed and litigate this as to where the children should live and attend school and have what sort of other parenting time will be determined by the court.
I'm in agreement with that, and then we just take that issue before the domestic.
Yeah, I think that saved you all some time.
That makes the most sense. Yeah, I appreciate
Okay.
that a lot. Yeah.
Okay, well, I hope that y'all resolve this thing, for the interest of children. And I've really been surprised how this joint parenting works if people live in the same town, if people want. But I think rather than what system you use, it is the people involved determine whether things work more than court orders do, or the legislature in its infinite wisdom can talk about these equal things and all that sort of stuff. But it comes down to whether people just sit down and prayerfully consider what's in the best interest of children. So I hope y'all do that. And I'll be waiting to hear a report back from you, okay?
Okay, great.
Okay, thank y'all very much.
Thank you.
Yeah. Kyle Stevenson versus Tri-County Electric.
Good afternoon, Your Honor. Anthony Pernice here on behalf of Sealbach. This is our motion for summary judgment. I have not received a response, so I don't want to belabor the court if the plaintiffs are not going to oppose this.
And Tyler Rucker.
You have to speak up.
Tyler Rucker on behalf of Tri-County Electric defendant. And we have a motion for leave to file a counterclaim.
Well, who's representing the Stevensons?
Thomas Carroll, Your Honor.
I don't see him here.
That appears to be the case, and we did not receive a response to our motion, Your
Honor. You represent the company that allegedly trimmed the trees at the request of Tri-County. Is that correct?
That is correct, Your Honor. And
I read your motion there. How closely did you trim them? Like to 1 inch to the ground or what?
Well, some of them were marked for complete removal. Others were marked to be partially trimmed. And all of the marking was done by Tri-County in the area that they have said is their easement, and it's an area beneath the power lines. And so Seelbach did exactly as they were instructed. And I don't think there's any question that there is a easement there, given the length of time those power lines have been present.
Neither one of you are from here. I was trying to figure out where this was as I was reading the pleadings. And it appears that this is located in the city here. Is that correct?
That's correct, Your Honor. It's directly across from the street from the Tri-County Electric.
Yeah, and behind the dental office.
Correct, Your Honor.
Yeah. Well, those walnut trees have been there for a long time, and they were planted just thick as thieves there. I don't know. I never did understand the real purpose for those walnut trees being there, but they were just planted one upon each other. At first, I thought they were going to transplant them somewhere, but in any event, how does Tri-County feel about
We have no
getting
objection.
your vendor out? So,
No objections.
well, I'll grant the motion. You're going to file a counterclaim against the Stevensons?
Yes.
And what was the basis of the counterclaim?
The basis was that they had knowledge of the easement when they went and planted the trees.
Yeah.
And as a result of doing that, and since they had knowledge of it, we had to.
You had to clear it, right?
Yes, I had to
Yeah.
hire Seelbach for that.
Well, I'm gonna let the vendor out, and because there would be you agree that you mark the trees and you'd have to indemnify them.
Yes.
And I don't think that that's any, with the amount of assets that Tri-County has, I don't think that their recovery would be endangered in any way by letting the vendor out. So did you, Mr. Pernus, did you send an order?
I thought we had, Your Honor, but I'm looking at my file and it's not clear if we did, but we will send one, Your Honor, if we have not.
Let me see here. Okay, the counterclaim this is the counterclaim order, so I don't see that you did. So if you'll send me an order, it just reflects that you're dismissed.
Absolutely, Your Honor. We'll be
Case
happy to
on
do that.
summary judgment. Okay, thank you very much.
Thank you, sir.
Yeah.
And you are signing that,
I am signing, even as we speak.
maybe excused.
Well, you don't, surely you want a copy that you can wave on the way home. It's the victorious trip you had to Burksville. We'll mail it to you. Okay. Thank you very much.
Thank you.
Yeah. Harden versus Harden.
Judge, Mr. Caldwell here, standing in for Mr. Cross.
Okay.
Your Honor, this is Mr. Harden's motion to set a hearing date. We made at least 2 attempts to get DRC dates and convey them to Mr. Cross, but he never would respond with what was available to him. And I had no recourse but to ask the court to assist us in
Do you have
getting.
Mr. Cross's calendar there?
I do.
I don't know how long, tell me what the hearing is going to be about.
The parties have no children. It's just basically 2 or 3 debts, division of a home, and some cemetery lots. It's basically the issues dividing up those things.
What's the deal here while we haven't reached an agreement on this?
We've made numerous attempts, but haven't been able to settle it.
And I can't speak to the facts of the case. I'm not familiar with it.
Okay, well, let's have Mr. Cross to be here on June the 23rd at the conclusion of the civil docket. We'll have a hearing that day. If it's just about a division of property, everybody needs to bring their proof, their witnesses and everything on the 23rd of June at the end of the civil docket. Okay.
Okay, I'll do an order to that
I'm
effect.
afraid if I sent it to the commissioner, it would be a while because he's ill.
So I didn't know that. I tried to call today, but I didn't get an answer.
I think yes, I don't think it's major, but I think he's under the weather, maybe had some kind of procedure. Okay, thank you very much. Northwest Bank versus Nanette Jordan.
Good afternoon, Your Honor. This is Cameron Griffith appearing on behalf of Northwest Bank on its motion for judgment.
Okay, just check, make sure service is proper on that. Only thing I need to check to make sure they're properly before the court, okay?
We originally attempted service via sheriff, but then we received word that they had moved to Florida. So we contacted the Secretary of State, I believe back in March.
Yeah. Sure, what? Where did you get this address for Nanette J. Jordan?
The Florida one?
Yeah, that's, you tried to do a long arm on it, right?
Yes, we did long arm. I believe we received that from the bank, our client.
Yeah, was it in a document? That's what I mean.
I don't have it in front of me. I can provide the court with that.
But look, wait just a second. I've got your document here. It's attached to the complaint, right?
Well, complaint, we originally tried to serve her at her
Misty River Run, Burkesville, Kentucky.
Yes, that was the original because that's what all of her security.
Do you have the vehicle?
We have already sold the vehicle. We repossessed it.
So this is deficiency.
Yes.
Okay, well, I'm going to go ahead and sign it. It appears to me that you made a.
Thank you, Your Honor.
Yeah. And if they want to come back at some time and attack the judgment, they can.
Okay. Deal.
26. Okay, thank you very much.
Thank you, Your Honor.
Okay, the last case on the docket was Brittany Dale Taylor versus Jimmy Dale Taylor.
Your Honor, Ms. Taylor is requesting a default divorce.
How was Jimmy Dale Taylor served?
Your Honor, we served him through the clerk's office, who then perfected process through Secretary of State's office. And there is some sort of mix-up where we have not received the confirmation card back. However, that is why I have attached the text messages that show proof Mr. Taylor has been served. We requested sole custody in the petition for divorce. And in these text messages, he responds asking Ms. Taylor, "You want sole custody? Did I read that correctly?" We also attempted to do certified mail with the motion for today's hearing.
Well, here's the thing about the Secretary of State's office to this day. Was served with the Secretary of State was served with the summons accompanying, the office served with him by sending a copy of the summons accompanying document via certified mail return receipt requested. To this date, the office has received neither the postal return card nor the undelivered letter. Should we receive either, a supplemental return to the court will be made. I don't think he's before the court.
I'm sorry.
I don't think he's before the court.
Your Honor, if we could take testimony of Miss Jessica Milam that looked up service of the petition, and we had a time of Mr. Taylor being served on March 14th and him picking it up at 7:49 in the
Where
morning.
did you get that information?
I done the tracking
On the document? United States Post Office with their tracking number on it?
from the Secretary of State.
Wonder why they didn't get the return card.
We have not been able to figure out that issue.
You have a copy of that, did you say?
Um,
Did you print it out? What I'd like to do is print that out and take it under submission. And you might,
When we go back on our mail, it's showing not served.
showing it's not served now.
yes, and I do not understand what the mix-up
It's
is.
United States Post Office. That's the issue.
Absolutely. But that's why I attached the text messages.
I can't sign one where they say it's not served,
Okay.
even if they did earlier. So the text messages from him were that he obviously had the document or he couldn't have responded to it.
Yes, Your Honor.
Let me take this under advisement. And I want, so you don't know why, the clerk's office didn't know why it says not served.
Well, it's the post office. It's what the post office said. They can't remember.
Well, you're kin to everybody out there and they can't get any information.
I know, I've diligently worked on that. I also have more text messages I can submit that shows he received the motion. He received the copy of the motion with the text messages attached, and he responds to her.
Why don't you file a little brief with an affidavit of your client? If you file an affidavit to your client that includes those things yet?
Yes, sir.
There's no affidavit yet. I mean, your client hasn't filed an affidavit.
No, not at this time,
Why
Your Honor.
don't you let your client file an affidavit
Okay.
and attach anything to the affidavit that she thinks supports her situation. And that way we'll have something under oath, and then we'll, you file an affidavit that you checked it earlier at the request of counsel at that time, but then the status of it changed or something like that.
Okay.
And I'll take their submission.
Thank you.
And have you, the default is a default, but have you overreached on what sort of result that you want to get from out of this thing?
No, Your
Why
Honor.
is he gone? Did he just leave? Did he desert or?
We were currently living in Texas for the past 6 years. He chose to step out on our marriage, and I decided that I had had enough.
Yeah.
So the boys and I moved back to Kentucky in
Are you
July.
from here originally?
Yes. My maiden name is Roach.
So you're in the south end of the county somewhere.
So the boys and I have been here since July the 3rd
Of last year?
of last year.
Okay.
And I waited the proper 180 days before I filed.
Okay. Okay, well, just give me an affidavit about service. And then, and then include in your default that he's properly, the court makes specific finding he's properly before the court. Okay.
Yes, sir.
Okay, thank you very much.
Thank you.
And as soon as we take a look at that, we'll decide whether we can sign it.
Okay. Thank you, Your Honor.
Thank you.
Thank you very much. Dare County Child Support. Sure, you know everything.
Good afternoon, Your Honor.
Hello, you know everything you want to know about nursing homes, I guess. Now, I didn't know you're on there. Dean, this is Adair Circuit Court meeting in special session in Burkesville. The first case is Tara Dean versus Alan Sparks.
Your Honor, we are asking for an order to review this on July the 28th at 1:30. Mr. Sparks is in rehab right now. So we are just asking that take place. I believe it's court ordered.
Okay, if you submitted an order, if you haven't, you submit one down on that. Okay, Nicholas Watson versus Stephanie McLean.
And Your Honor, we would request that this be removed from the active docket as she's making her monthly payments by wage garnishment, and the
Okay.
child is getting ready to turn 18.
If you'll submit an order.
Oh, very much. Okay, thank you, Your Honor.
Have a great day. Thank you for your
You
patience.
too. Thanks. Bye-bye.
Is there anything else to come before the court?